You are ready.
Cool, and we will begin. Welcome to the April 3rd, 2025 meeting of the Public Safety and Sanitation Committee. My name is Stuart Desser, and I'm the chair of the committee. Tonight, we're joined by Assistant District Manager Brendan Berth. This meeting is called to order at 18:31. As a reminder, New York State law requires all committee members who are attending remotely to have their cameras on and their full names displayed from the start to the end of the meeting. Members of the community who are not on the board and are attending virtually, you can raise any questions or comments you have through the Q&A feature of Zoom. Community members who are here in person can raise any questions you have by raising your hand. If there's time following the committee's discussion, we'll field your questions as a matter of practice. Our neighbors' voices are important to us and we always field your questions. Would anyone here tonight like to volunteer to take the minutes?
Isn't it, we usually give it to the person that's not here?
The reason is that Anne is doing some other minutes this month, so
I see.
I'm being unusually kind. But she volunteered to do it if anyone else doesn't want to.
I can take it this month.
Do you want to?
No, I don't want to, but I can to help out Ann.
That is so sweet.
How about Ann?
Excellent. We have a volunteer. Thank you so much.
Thank you.
The agenda for tonight's, I'm sorry, we have to take attendance first. Look at that. So Brendan will call the roll.
Okay. Committee members, I will call your names. When your name is called, please say present. I will announce if there is quorum. Stu Desser,
Present.
Justin Goldberg,
Present.
Gloria Haig.
Present.
Okay. Rupal Kakad,
Here.
Steve Perez.
Present.
Michael Rowe.
Here.
And Ann Feldman won't be with us tonight, but we do have a quorum.
Excellent. So the agenda for tonight's meeting was distributed ahead of time and is reflected on the screen before you. If there's no objection, I will be changing the sequence on the fly based on the clock. If you object to adopting the agenda along with the qualification that the sequence will change, please raise your hand.
What did you want to do? What did you want to change?
Things will change based on the clock.
Okay.
Seeing no objections, the agenda for tonight's meeting is adopted. Board members all know the rules. Everything except problems with meeting technology is on the record. Only one person speaks at a time and so forth. The first issue is the NYU Langone request for federal monies for a CT scanner for second scanner. Just a note, the congressionally directed spending request is the formal language meaning earmark. And I believe Rebecca Berger is with us. Yes. And Rebecca Berger is the Director of Policy, the Senior Government Affairs Analyst with NYU Langone. Rebecca.
Hi, thank you so much. We are asking for a letter of support for our federally directed spending request because this was actually funded last year, or this was selected to be funded last year, but it never got funded because the federal government never passed an appropriations bill. So while it got selected, we never got the funding. So we're applying again this year. It's for a new CT scanner for our emergency department. And basically just emergency department volumes are at are higher than ever, in part because we're already seeing more volume because of Beth Israel closing and reducing services. So we need another imaging machine for increased capacity. And the CT scanner does a lot of does imaging that is life-saving in different scenarios, such as stroke and other ones. So I can give more information, but that's basically, it's just we're at capacity. We want to serve more people faster with this.
So this would be your second scanner, and do you know how many scanners, how many CT scanners Beth Israel has or had?
No, I don't know.
And you're next door to NYU, I'm sorry, to
Bellevue.
I'll get there, to Bellevue. Bellevue also has a CT machine, correct?
Yeah, I would believe so.
Well, the question is, I think, you know, how does NYU Langone and Bellevue essentially divide the number of emergency patients? How are they directed to one hospital rather than the other? You know, because Bellevue may also want another CT scanner, so the question is how we decide priorities.
Um, I, well, I don't know how you decided the priorities, but I can say that in terms of how our patients directed, well, currently ambulances can give 3 options, for where patients go, and it's based on how close they are. So that's a great question. If someone's coming from uptown versus downtown, they may be brought to Bellevue, but patients also have some choice, where they go. Out of those 3, and uh it's our volumes are high. We don't send patients between NYU and Bellevue. It's 2 separate places, so it's just different patients have different decision needs. With the emergency department, of course, we take all insurance in our emergency department, but I guess it just is a few different factors where the ambulance would go or where patients choose to go, because not all emergency department patients arrive via ambulance.
Committee members or board chair, any questions?
And I just, if I could, as the chair, we're always happy to support you, but we're wondering if we could do it a little sooner, because we would have had this go to the health committee, if we could, but just the way the timing works. So I'm not sure if you know ahead of time, you can send us these requests earlier. I think we're more than happy to support our institutions. But that would be, if you could, then it's just a lot easier for us.
Yeah, and yeah, I understand. And if we needed to put this on April 9th, we were okay with that. We understand. We appreciate the short turnaround. We just got leadership approval to move forward with this. I sent you the request as soon as I got it. But I'll send that. I'll give that feedback to others who may be able to take it into consideration when asking you all for a letter of support.
Thank you, and we understand you don't always have a lot of time ahead, but that's just, unfortunately, it's the way it works.
So I have a question, maybe to step back and just kind of look at the larger context of what's happening right now in our community and in the city and country. I have to say I'm deeply disappointed and disturbed by NYU Langone's policies in deciding that they are no longer providing gender affirming care to transgender youth in the city. This is against the law. They've been put on notice by the state, by the city, and our representatives, Harvey Epstein and Kristen Gonzalez, wrote a letter to NYU Langone to which they received no response. In addition, and these are only 2 things that I know about just because I read things in the paper, NYU Langone canceled a lecturer who was about to present. She's a emergency room pediatrician whose lecture was canceled by NYU Langone because she wanted to talk about the effects of getting rid of US aid and how that affects humanitarian issues around the globe. She was disinvited and her lecture was canceled by NYU because it was considered anti-government. So when I see NYU Langone capitulating to the Trump administration to this degree, I am deeply concerned for our community. And I don't think we have any business turning around and saying, sure, we'll sign any letter of support that you guys need. Because this is outrageous and I'm very upset about this.
A couple of questions I'd like to ask you. You mentioned about the application that was first applied for last year, was it, you said? When was that applied for in the beginning?
That was applied for this time last year, and it's an annual process where we apply for this as was explained, that it's was previously called earmarks, and now it's a more formal or transparent process where we put in an application. And we applied for an additional CT scanner to Senator Schumer's office, and it was selected. But unfortunately, the appropriations bill was never passed, so we never got the funding. So we are applying again.
Mm-hmm. And how much is this CT scanner? That what is the ask
Um,
for the funding?
It's not in our resolution.
No, I don't think we need these together.
Nope, it's not in the resolution.
yeah, I'm sorry. That's a great question. Let me confirm that.
I just find it interesting that NYU has to ask for funding in the first place. They have footprint all over Manhattan. And I think the application, it sounds like you would have already, I don't think that Israel was closed at that time. You guys can correct me if I'm wrong. But you're presenting it as if, you know, you had applied for this in relief of them closing, but they had already, I don't think they were closed at that time. I'm just trying to put it all in perspective. But I would love to know more about how much this ask is from Senator Schumer's office. And I would ask that we do not decide on this tonight.
In a short while, I'll allow you to make a motion to postpone this to a
Yes.
definite time, but
Well, thank you for that, for those thoughts. Completely agree that Beth Israel was not closed. Based on the information that the emergency department gave to me, as far as I was told, we saw an increase in visits even after the news was released. So I can share more information on that if you would like, but that was what we heard, that we were seeing an increase last year based on the application I worked on last year. That was a reason that was given. So I'm not trying to portray anything right now without, you know, against the facts or anything like that, but that was just sort of, they saw the emergency department leadership saw an increase starting last year.
More questions?
Do you also take uninsured patients? Because Beth Israel that is closing, they used to take uninsured as well as people on Medicaid. So
Yeah, I can send you our financial assistance policy that details that we provide financial assistance to people up to 600% of the poverty level and a discounted rate up to 800%. So I can share more about that if you'd like, but I mean, it's always a case by case basis, but the emergency department is very all emergency departments in you know, as you know, have to take Medicaid, and we have a generous, well, just generous in comparison to other hospitals that would be up to 100% of the poverty level, whatnot. But I can send you our financial assistance policy for the emergency department. But if somebody is admitted, then it would be case by case.
So what does that mean, case by case?
Well, each patient has a different, you know, I mean, you know, I go to the hospital, you go to the hospital, it's two different, my finances, my insurance, it's different than yours. So that's just how it works. Right. I mean, that's sort of, I'm not trying to make a case from NYU Langone, and I'm just talking about how each patient has their own like if you're admitted to the hospital and I have one type of insurance and another person has a different one, then it would be each case would be different. It wasn't supposed to be like meaning anything beyond that.
Just a last comment is canceling a speech and then calling it anti-government is extremely disturbing. Like that is just plain disturbing, and there's no other way to put it. Calling it anti-government. This is straight up capitulating to fascism.
I'm not familiar with that, but if you want to send me any additional information, I can ask
It's in
someone who
today's.
might have more information.
Go ahead.
Can I also just ask, do you know if NYU Langone is planning on changing its policies regarding gender affirming care and complying with New York state law?
NYU is in conversation with all appropriate parties. I don't make those decisions. And if you would like to talk to us more about it, I'm happy to set up a meeting with me and someone else. But I am here just to ask about this letter of support. But if you would like to talk about it another time, we're happy to clarify.
Just a comment, I mean, just listening to you, I can tell that, you know, it's unfortunate, maybe we should have someone that's, I don't wanna say your superior, but someone that can answer the questions that we're asking and to come to the table and have this discussion with us, because we are the community board. And you're asking us to pass this, and I feel bad for you that you're put in this position and you don't have the information on your heels for us, and, you know, I think someone else should be speaking on behalf of NYU to answer our questions.
So the cost is 2 million for the request. And were there any what were the other specific questions?
Well, we had a few. We wanted someone to come and speak to our remarks.
And the remarks being the person that was canceled, the speech that was canceled, that was one. I would like to take notes to get back to you on them.
Yes, that is one, and the other one is your policy on providing gender affirming care consistent with New York state law, and 2 requests from state legislators that have gone unanswered.
My office is in conversation with the state legislature, and if you would like to hear about any additional information beyond what you read in the news, we'd be happy to have a conversation with you about it. I'm here to talk about this particular issue, and if that is a consideration for you in supporting our CT scanner, then we'd be happy to talk about it.
Well, I mean, this is the venue for talking about it because we're a public body. So we cannot have private conversations. That's not how we work. I'm not allowed to speak to you privately about this. It has to be on the record in the public. So if you want to come back with somebody else who wants to have a conversation, we have it here, or we have it in our health committee. That would be another place to have it because that's kind of the most appropriate committee in our
Yeah,
board.
could I just say that if we want to continue the discussion, we will have it in the health committee, but I think we really should move forward with this particular issue. If we want to support their request for a CT scanner, we should do that. If not, we should also let Rebecca know.
One at this time.
Yeah.
Yeah, I mean, yeah, thank you. We're just for gender affirming care. If this is the venue that you want to hear, if to your point, if this is the venue that you need an answer, we were pausing until we could get more information from the federal government. Only on people between new patients between 18 and 19. We are, that's just new patients who have not started their journey between 18 and 19. And we are in active legal review. We are working on the issue. We are in conversation with Kristen Gonzalez. We deeply respect her position. And it's an issue beyond me And that is not because I'm unable to discuss it with you. It's just these decisions are being made at a very high level. So yeah, it's just new patients between 18 and 19 starting their journey until we can understand the legal situation that is changing very quickly and rapidly. And we apologize for any distress. Or I personally, I can't really speak for anyone else. I apologize for any distress that might have caused anyone here. But that's not a decision that I can speak to beyond that in real time because it's being made day to day we're working on it.
Okay, I'm also interested in my earlier question. You've got Bellevue next door, which may not be as well funded as NYU, Langone. And what if they decide that they want a CT scan, another CT machine? Is that funding are they going to be deprived of that because we've given funding or because there's been an earmark to NYU Langone? You may not have the answer to that, but I think that's a question that we want to answer. Have answered.
And I might say that, I believe that the fact that, the federal government and our representatives at the federal level will make that decision. It's not something that
But we would be supporting, just NYU Langone in this.
we haven't been asked to support anyone else.
Mhm.
Gloria has her hand.
I'm sorry.
Gloria.
Oh, Gloria, sorry. Didn't
No
see-
problem.
Okay.
I guess my question is this to Rebecca. Does this letter of support have any big difference to you putting through this ask again, since you already did ask and get it? I mean, you literally can go back and say, you already said we could have. So I just want to know why this letter of support and what does it actually mean to this new ask? And like, why did you come to the community board, I guess is my question.
Yeah, I mean, that's a great question. I think we typically look for support from our elected officials and community board. If you don't feel able to offer support, that would be up to you. It's, our basic procedure. Like we go to our direct city council members and the community board for it's a new application. I mentioned that it was funded last year just to say that that it was chosen but not funded, just to say that it it wasn't funded. I'm sorry. We call it, I'm just not using the right, I'm just skipping over. We thought it was funded because it was chosen, but it never got funded because it would have been funded in the new appropriations bill, but they just, as you know, kept passing continuing resolutions with no new funding. So it was set to be added to a new appropriations bill, but no new appropriations bill was passed. So we are putting in a new application for next year for it to be
Okay,
funded.
and who do you have letters of support from right now?
Councilmember Powers.
Okay, good to know. Thank you. Appreciate that.
So we have options. Someone can move to the previous question. We can vote, and it may go down. It can be referred
Move to
the
table.
health committee, or it can be postponed to another time. Hello.
Hi, good question. So we're voting on a resolution support.
Brendan has drafted a resolution, that we can take a look at if you'd like.
Because I was gonna say, what would you think about, and I know this probably, you'll feel it's not strong enough, but including some language in the resolution, voicing that, because I do think the issues are somewhat decoupled in the sense that like there are people that could be potentially injured by not having, or not say injured, but they don't have their medical accessory to access to some of this medical technology. On the other side, I think that everything that you're saying is legitimate. So I wonder if there's a way to express disfavor and concern, or not, or basically repudiate how they're acting. But that being said, I also can understand that you might feel that it's not strong enough. So I wanted to bring that up as a possibility.
Yeah, I mean, once we support this, we lose all leverage.
Yeah, that's what I.
There's no, why would we even, I mean, we might as well just say we support them. Sort of.
Although I do know that we can vote it out of committee and the full board can consider it. I'm not suggesting we do that, I'm just offering that as
I mean, we can take a vote. I can guess how it will turn out.
Yeah.
I call the vote. Call the vote on the proposal.
Are you doing that?
Yeah.
Second?
Was the proposal to table or to?
No, we're voting on the resolution itself.
Voting on the resolution itself.
Call the question. Before we do that, though, I think we should look at the resolution.
Yeah.
Yes. So I'm going to. So this is the resolution. I did email it to the committee. I'll scroll to.
It's quite short. Why don't I just read it quickly? It goes that NYU Langone Health has submitted a request to the Office of United States Senator Charles Schumer for funding for a second CT scanner in the Perelman Center for Emergency Services. Access to imaging tests performed by a CT scanner can be the difference between life and death in the case of stroke and other acute treatable events. An additional CT scanner at this site will help patients receive prompt imaging access, ensuring that critical life-saving diagnoses can be made. Access to more robust emergency services at nearby hospitals is critical in light of the pending closure of Mount Sinai Beth Israel Hospital in Manhattan Community District 6. Therefore, be it resolved that Manhattan Community Board 6 supports NYU Langone Health's congressionally directed spending request for funding for second CT scanner in their Center for Emergency Services. Okay, now if you wish, you can move the question.
I move to vote on the resolution.
You have to vote. Or no, should not pass it, right?
I mean, I'm calling the votes, take a tally of votes.
You can vote for or against,
Yeah.
Okay,
or not entitled, or abstain.
I've never figured out if there's a small committee we need to, but would anyone like to second the motion?
I'll second.
Yeah, but
Or actually, I'd rather not second.
Okay, the question then is, should this resolution as currently written, pass or fail?
Okay, so when I call your name, please say whether you're in favor, opposed, abstain, or not entitled. Stu Desser,
In favor.
Justin Goldberg,
Abstain.
Gloria Haig,
Opposed?
Rupal Kakai,
Opposed.
Steve Perez,
Opposed.
Michael Andro.
opposed.
Okay, so with one in favor, 4 opposed and 1 abstention, this resolution fails.
Okay. We can, of course, take this issue up or a related issue at another time, but I think this probably would go better to health, at that point.
Sure. Why wasn't it with help?
Because it's time sensitive.
Yeah.
And
Oh, right.
before April 9th, or.
Yeah, I can, so yeah, the congressionally directed spending deadline that NYU Langone said was April 4th. That's actually the Senator Schumer's deadline. I did ask Langone as to whether, like, it passing this committee and then April 9th full board, assuming it passed committee, which it did not, of course, whether that would have been sufficient for their timeline, and they said yes. So it's really an issue of timing.
Yeah, and the timeline when Schumer said, okay, was that just this week or when
He
did that
didn't
happen?
say okay.
He didn't say okay.
No, they're applying right now. Just making sure.
Okay, Rebecca, sorry. This is a question that can be revisited, of course, by the board. But you heard the vote for tonight.
Yeah, totally. Completely understand. I hope that you know that I'm really respect your questions and just tried to do my best to share NYU Langone's position, as well as I grew up in CB6. I'm been working at NYU for 5 years. You know, I'm sorry, maybe I'm not as high up as you would hope to be able to talk to someone, but I hope to continue a positive relationship with the community board. If, you know, I ever come into your committee again. So I respect your position from a community standpoint. And just Brendan, really, it would have been okay if we did it on the 9th. And I'm sorry for the short notice, but yeah, trying to give you as much information as I have or that we've, you know, in general able to share. So
You did your job, Rebecca. This is no reflection on you.
okay. Yeah, same to you. Same to you all. Yeah, same to you. So yeah, no problem. And I, you know, hope that we can continue working on these issues together.
Great, thank you very much.
Thank you.
Thank
We're
you.
going to move on to our second agenda item, which tonight is going to be discovery. This is our second session on proposals to amend discovery law in criminal law. For those who haven't been here before, discovery is a process by which the prosecutor and the defense exchange the evidence they hold. We're taking the subject on not as an intellectual pursuit, and certainly not because it's a big headline in the Daily News, but because we care about justice in our community, and discovery is a fundamental component of justice. When a case is tossed out because the prosecutor violated an obligation under discovery, the crime victim and the community are both losers. And when evidence is inappropriately withheld by a prosecutor from a defendant, an innocent person wrongfully accused of a crime is the victim, or can be, and once again, so is the community. To quote Gloria from our last meeting, speaking to our guests from both the DA's office and the Legal Aid Society, you're all lovely people. We trust that most prosecutors and defense attorneys do care about justice, but our system of criminal adjudication is adversarial. The principle being that if each side battles fiercely, truth and justice will emerge. So reality is never quite that neat. And both prosecutors and defense attorneys sometimes game the system, not necessarily because they want the innocent convicted or the guilty to go free, but because they believe in the merits of their case, even when the evidence may not be so convincing. And so they'll push the rules in order to win. That's why getting this right is important. Our last session was mostly having the advocates get us up to speed with their often opposing viewpoints. Tonight's going to be dedicated to a conversation between the committee and the panelists. Those of you representing legislative offices are also invited to participate as our members in our community. If you missed the last meeting and want to catch up, then if we approve the minutes from the last meeting tonight, I think there'll be a fair compendium of the topic that will be someplace on our website. Just one thing before we start, I realized too late last time that there was some terminology at the meeting which would not necessarily have been clear to non-lawyers, prejudicing a defendant, strict liability, impeachment. So let's try to explain what might not be obvious to everyone. I'd also appreciate if somebody would, one of our panelists would explain just rudiments of how a case proceeds from arrest to arraignment to indictment or information and so on, and then fit the timelines from discovery law and the speedy trial statute into those timelines. I could, of course, cold call, but I'll ask for volunteers. Kelly?
Sure, I'm happy to volunteer. And 88 Foreman, it's great to see you. We used to work together in the Bronx, or on opposing sides, but haven't seen you in a few years. It's nice
I know. We were baby lawyers together.
Yes, we were.
Let me just make sure everyone knows, because I should have done this. So Julia Foreman is an assistant district attorney in the Manhattan DA's policy council.
Yes.
Amanda is with us or not?
He's unable to make it tonight.
Not able, okay. Callie is a supervising attorney at the Legal Aid Society. We did invite both Senator Myries and Assembly Member Lasher's offices to come, but somewhat paradoxically, because of the budget deliberations, they weren't able to join this month. I hope that, we might consider a resolution for next month's meeting, but we can also have them join us then, before we discuss it. I believe we also have Joanna Sanchez with us, with, Assemblymember Epstein's office. Peyton, Schultes, the community liaison with, State Senator Kristen Gonzalez, and finally Wendy Brennan, with Senator Kruger is with us too. So with that, I'm sorry, Callie.
No, yeah. So thank you again so much for having us. I'm happy to sort of try to give you a quick crash course in sort of the path of a case in criminal court. And, Julia can add to that if I miss anything, but, hopefully I'll be able to do an okay job since I now train the new people in my office. So basically, the paths of a criminal case are slightly different for a misdemeanor and for a felony. On a misdemeanor case, the timeframes are shorter than on a felony case, and they start differently. So with a misdemeanor, the basic requirement for a case to go forward in general, and this predates discovery reform, it's always been the law, is that the prosecutor has to have what's called a sufficient information. So they have to have a signed, corroborated affidavit from the person who's making the accusation that makes out probable cause, essentially, of the crimes that are charged in the complaint. And then from there, right, the pretrial process begins. And it used to be, prior to the reforms, and this is why they were so sorely needed, that prosecutors would regularly state ready, at least that was our experience in the Bronx, I can speak to that like prosecutors regularly stated ready in arraignments if they had a corroborated affidavit, meaning if they had a signature from the complaining witness, they could state ready for trial, even though everyone in the courtroom knew we weren't starting a trial that day. We weren't even in a part of the courthouse that could hear a trial, right? So the case had to be adjourned. Motions have to be filed, right? There are what are called omnibus motions, which are just these basic requests by the defense for hearings, suppression hearings, to challenge the admissibility of evidence, and a host of other sort of procedural things. And what the 2020 reforms did in terms of discovery is they added to part of that, that prosecutors now have to provide discovery, so the evidence in the case, prior to being able to state ready for trial. So there's no longer the ability to say, I'm ready the moment the case starts before you've talked to your witnesses and gathered your evidence, right? You have to actually obtain the evidence in order to not only review it yourself as the prosecutor, but to share it with the defense. And then at that point, once you've spoken to your witnesses, they're ready to go, you're ready to go, you can state ready. The speedy trial statute, which also has existed since before the reforms, so that was something that was already there, and the same timeframes applied, okay? That requires that on a misdemeanor case, on a misdemeanor, which is what most misdemeanors are, a prosecutor has to be ready within 90 days of commencement of the case, so arraignment. So within those 90 days, prosecutors must provide this discovery and file what's called a certificate of compliance, which is a piece of paper that basically lists the discovery that they've shared and says, I've done my due diligence and I'm filing this in good faith, and I'm saying that I've completed my obligations. If they don't do that, unless there is some sort of exclusion from the speedy trial statute that applies. So for example, if you file a motion, if the defense files a motion during that period of time, however long it takes to resolve the motion, doesn't count towards speedy trial. If something else happens, like my client, let's say, as the defense doesn't appear in court, right? A bench warrant is issued, all of the time that the person is gone doesn't count towards speedy trial. So even with these new obligations for discovery, a lot of different periods get carved out of that speedy trial clock. So although it is a 90-day clock, it's frequently longer than that because things have to happen if things happen, right? Like a person bench warrants or there's a motion, the time sort of stops for that period. Now, that's sort of the basic rundown, right? If they fail to state ready within 90 days, or if their statement of readiness is effectively challenged by the defense, right? Because we say they weren't really ready, whether that's because they didn't comply with the discovery statute or because they didn't actually have their witness available, or they didn't really have a information that supported probable cause, as in their criminal complaint, that statement of readiness will be invalidated. So the court can say, you did not comply with your obligations in whatever way, right? One of those ways I just listed or something else. You're not really ready, DA, and you're going to be charged with the time following when you said you were ready, because that didn't happen. So that's the basic, I know that's kind of abstract. That's the basic concepts. The only difference with a felony is that, well, there are two major ones. One is that they have to pass the case by a grand jury in order for the case to be indicted. So grand jury, here's the evidence from the prosecutor. The defense and the defense attorney are not there unless the defendant's testifying. And it is the basic presentation of the basic evidence in the case, enough that will return an indictment, which requires a showing of probable cause. So they have more work to do basically before they can go forward on a felony to trial. Cases that never get indicted will just sort of linger until they either get dismissed or the prosecutor decides we're going to reduce this case to a misdemeanor. We're going to dismiss the felony count so we can proceed with it on a misdemeanor clock and is with all the misdemeanor rules. If it's an indicted case, then it goes to Superior Court. So it's a different court, different judges. And they have regardless of whether it's indicted, they have 6 months on a felony as opposed to 90 days. So, and homicides, to be clear, don't have a speedy trial clock. So cases cannot be dismissed pursuant to statutory speedy trial if it's a homicide. So all felonies other than homicide are subject to that 6-month clock. But again, just like with the misdemeanors, all of these extensions apply. So if at the Supreme Court arraignment, which is after the indictment, there is going to be a motion schedule set. That motion schedule will be about 3 months. That extends their 6-month clock by about another 3 months alone, right? So that is the basic overview. And again, those same discovery obligations apply on felony cases. They just have a longer time to comply with them.
I'll ask Julia to respond in a second, but I want to ask you first, when do these clocks, both the speedy trial clock and the discovery clock, begin?
So there are timeframes in the discovery statute that are shorter than that, to be clear, but they're totally sort of useless because no one really complies with them. The prosecutors don't comply with them, right? And the reason is because in order for there to be a consequence for a prosecutor failing to file, so the statute requires that they provide discovery as soon as practicable after arraignment on the case. So you get arrested, the next day you go to court and you get arraigned as the defendant, bail is set or not set, right? That's when the case begins. That's when their obligations to share discovery begin. And the statute actually says that they're supposed to provide it as soon as practicable, but no later than 35 days if the person is out, not incarcerated, or 20 days if the person's incarcerated, with some additional extensions built in. They never, ever, ever, it's been my experience since 2020. I think ADA Foreman will agree with me. It is very unlikely, very uncommon that discovery is complete or even close to complete within that time frame. But there are no consequences for failing to meet those timeframes. The only consequences come from failing to fulfill those obligations within the speedy trial clock time. So all the dismissals that have been discussed that are related to discovery rather, all are speedy trial dismissals. They're all dismissals where the court said you did not do your job within the speedy trial time. It's not, so they exist and, I wish they were more effective, but they're not. They don't have any real teeth because the consequences are gauged by whether we can establish prejudice. And that is actually the standard. And I don't want to start advocating for my position again right now, but that is the standard that the governor is hoping to put into the statute again as a consequence for their failure to comply with the discovery obligations by the speedy trial. Essentially, like, it will mean the speedy trial consequence doesn't really exist anymore because they're replacing it with the same scheme that hasn't effectively imposed consequences for failing to meet the shorter timeframes. I hope that
Okay.
makes sense.
Let's let ADA Foreman respond. Was that an objective lesson, or do you disagree with it? And also, if you can just explain a little bit better the relationship between 245 and the relationship between the discovery law and the speedy trial law.
Sure. So I think up until, and I think Kelly can agree, she advocated for a position towards the end, but up until that point, it was a very, very, objective and realistic overview of what goes on. The only things I would add, and I apologize for my voice. I have a 3-year-old, so I have every germ in the world, and have lost my voice. The only thing that I would add is on the front end, when an arrest is made and brought to the DA's office, starting, and I right now can only speak for the Manhattan District Attorney's Office, starting in our Early Case Assessment Bureau, ECAB, the minute that that case comes in, we start actively pursuing all discovery. Obviously, especially from NYPD, because that's who brings us the arrest. But we start our efforts to collect and compile discovery from the minute that arrest hits our office. At that point, we determine the charges, we draft the case, and then it goes over to arraignments, where Callie started her explanation. In terms of explaining the connection between 245, the discovery law, and 3030, that was put into law when these laws were passed in 3030 subsection 5. I'm not going to get too into the weeds because I know that attorneys have a chance to do that.
Trial
Yeah,
statute.
in the speedy trial, there was an additional subsection added that talked about our statements of readiness being tied to a valid COC being followed. COC being the certificate of compliance with our discovery obligations under 245. So that subsection is what created the link between the two. And to, add my advocacy, that is the section that we are hoping will better reflect what was put into the discovery laws in 2022, to make sure that the sanctions and remedies are, for a delay or failure with our fulfilling our discovery obligations is proportional to the harm or the prejudice caused to the defense.
Okay, I'm gonna open this up to the committee now for questions, and this is gonna be a conversation, but I do want to ask you one question first. Last month, Andy Warshauer seemed to indicate that, at least for the Manhattan DA's office, you would be okay if the language was not changed from related to relevant. Is that the position of the Manhattan DA's office?
What I would say is that I think since last month, language has been going back and forth between all the parties up in Albany. So the governor's office and the Senate and the Assembly are going back and forth with a lot of different language changes. I don't believe that we feel completely married to any particular wording. It's more about what, I guess, the spirit of the law or the legislation is looking at like, and what it will result in is. So I don't know if that answers the question. What I can say is, as the language is continually changing, we're simply trying to emphasize the concepts that we think are most important to go through.
Well, you understand, we're looking for areas, for points of agreement, and so it looks like everyone, for instance, agrees with S613. Which says that prosecutors, so, committee members. You've had lots of questions.
Yeah, there's a note, I mean, I made some notes today because I went back and watched, last month's, discussion. And I wondered how many district attorneys have to agree in order to approve this language. How many does it take? Because it said something about going back and checking, or there needs to be a certain number of district attorneys that agree with this, or there's a group of district attorneys that would have to agree. Is that true, or am I just?
Not entirely sure. Again, I wasn't here last month, so I'm not sure. That was said. Andy may have been talking about how, um, the five city DAs were obviously more in communication with each other than we are with people outside the city. And then there's DASNY, which is the District Attorneys Association. So
Yeah.
I'm not entirely sure what
Might have
was
been in
said
relation
last
to
month.
613, Julia, that he was
Oh,
saying,
about 613?
might have been. I think he might have been saying,
Oh,
speak for our office, and that it's not clear whether all the DAs across the state, that's my memory.
right. Oh, okay. That makes sense. Yes, yes. So again, I can also only speak for Manhattan, although I believe that the Brooklyn DA also came out in favor of it. But I think that I can speak for both of our offices, to say that while we do support, um, Senator Myrie and Assemblymember Lasher's bill, we do not feel like that totally addresses the issues that led to the governor's proposal. Um, the way that I kind of have been describing it, I say it in two ways. We think of it more of as an and not an or it's more like, 613, the Lasher Myrie bill is like the glass of wine that I'm ordering, but that doesn't address that I also would like some food to eat.
Mhm. And how much does this go really, how much does all of this go back to what is not happening at the police department on the reporting side? So you guys, and if you could walk us through exactly, when you go to find those reports, or let's just go back even further, what is mandated of the NYPD in reporting cases? Because it seems like, from what I've learned, that there's a lot of missing information, and that this information is always missing, and that's what holds everything up. If you could explain that a little bit more as to, really what their responsibility is and why this is happening.
Sure. So I just want to be completely transparent. I'm policy counsel at the office, so I actually don't handle cases on a day-to-day basis. But from what I understand, a lot of the issues when it comes to, missing items from NYPD, a lot of the time in from the cases that I've learned about and that I've spoken with line assistants about, the people who do handle cases, it's a lot of, it's a big department and there's miscommunication. So for instance, um, the arresting officer is usually the ADA's point of contact. I've heard examples of cases where it wasn't known that, like, let's say a sixth officer showed up on scene. The arresting officer just didn't see that person, didn't know that they were there. It wasn't brought to their attention. So we didn't know to ask for that person's, uh, body worn camera footage. We didn't know to ask, to speak to them and find out what went on with them. In other instances, even when it is technically NYPD generated or derived data, like with Zolpa forms, that's not stuff that NYPD necessarily has in their possession as well. So it needs to be found.
Zolpa forms, you said?
Do you want me to jump in on Zolpa just for a second? The Zolpa
Sure,
form
I have an example if anyone wants to see one.
is, you can, but just so you know, it's generated by NYPD and it's kept
Right.
by NYPD. So it is in their possession. But that's just, it's an easy thing to request. It exists in every case. But I just want to make sure that that's clear.
I'm sorry, what form is that?
It's an acronym. I can't remember what it stands for. It's essentially a form that has a lot of information about a person's movements when they're arrested. So when they're arrested, it'll document the time of their arrest, the time that they get transferred to the precinct, the time that they get transferred to the courthouse, any statements that they've made get put in there. It'll also document some of what's sent to the prosecutor by the NYPD initially. So it also has some information about discovery and about when a person was lodged, about when the docket was actually filed. All of these things actually do, from my perspective, and this might sort of in real time show you where there's some differences sometimes between our perspective on what's relevant and or related and ADAs, right? But I think that, and I don't want to take over, I don't want to I just wanted to make sure that it was clear that a ZOPA form is in fact an NYPD document.
We're fine if the two of you beat each other up, as long as you.
No,
Not
we're
trying
not.
We'll get to you in just 1 second, Gloria. What's a pre-arraignment report and why is it important to the defense?
So a pre-arraignment, to be totally honest, right? Like a pre-arraignment, they're called a pre-arraignment notification report. They are not always useful to the defense, right? Like occasionally they will have very little unique information in them. But the problem is that there's no document that I can say never matters, right? In one case, and in many cases, it'll have zero use. In fact, there are cases where surveillance footage has zero use, right? Like you think that the surveillance footage is going to be helpful. It's totally blurry. It's unusable. But we would never say that they cannot give us surveillance footage just because, well, it might not actually be useful, right? Like in most cases, it will be useful. And so the issue we have in terms of drawing lines based on, well, this document versus that document, rather than everything that's in the possession of NYPD, is that it starts to make certain assumptions based on the nature of a category of things, which you really can't do when you drill down on like the case by case. Like I've actually used a ZOLPA form, believe it or not. I can't say I've used a pre-arraignment notification form in a case, but I have used a ZOLPA form, and so I don't want to exclude that like a pre-arraignment notification form might be useful to one of my colleagues, right? And one other thing quickly I'll say, because I want this to be about your questions, but is that I think one thing that's really important to understand is that there is no such thing as like an automatic dismissal. Cases are not dismissed simply because prosecutor or because a defense attorney says, I'm missing these 10 items. I mean, I could show you the 20 cases that I've helped litigate in the past 2 months where we have lost all of our motions, where we've done just that, because judges have found that the prosecutor was diligent and any failure to provide material in a timely manner was not the result of a lack of diligence. So judges are required to make that assessment. It's not about just like, oh, you missed that one form. I just want to make that clear.
Before we get to Gloria's question, Julia, do you want to respond to that?
I do. So I appreciate, the description, and I actually join in what Callie said, that I don't think it makes sense in any respect to say it doesn't matter if you don't turn over X, Y, or Z. Because I appreciate, as Callie said, she had to use a ZOLPA form once. It was relevant, it was useful for her case. I think where we diverge is, one, I absolutely understand not every single case is getting dismissed on these motions, but when they are getting dismissed and it is based on a pre-arraignment form or a ZOPA form, and when that information is then reviewed and shown to be either duplicative of information that was provided in some other context, or that it is not really related to the case, nor does it cause prejudice or harm to be suffered to the defense, we do see them dismissed. Not every single time, but we do see them. And for those times where it does happen, and when there is a victim or the community at large, it seems like a so severely disproportionate response to a delay or a failure to turn something over to dismiss these cases. So that's why within the governor's proposal and what's being discussed up in Albany, it's not saying absolutely no more dismissals. It's saying, let's look at the harm. Let's look at what the result of this delay or omission was and determine what the appropriate remedy should be. You know, like one example that I know is kind of old was that a photo of a domestic violence survivor's injuries was belatedly found and turned over. And our office asked the court, you know, we know we're turning this over late. We know that, you know, the clock is run. What we're asking is that we're precluded from using this. If the defense, for some reason, finds utility in using the photo of injuries sustained by the victim, they can, but we won't use it. We think that that is a proportional remedy. But instead, the case was dismissed because of the way that 3030 is currently written. It does not allow to look at the proportional remedies that already exist in 245.
Yeah, I know Callie wants to respond, but we're gonna give Gloria a chance to ask her question first, because she's had her yellow hand up, and it must be tired.
Oh, I forgot about that hand. I was so engrossed. I like that hand. First off, I had a question, but then I just a little bit to what I'm just hearing, because judges make the decision to dismiss, correct? I just want to clarify that.
Yes.
So this is a judge's decision based on everything that that judge knows and has. Okay, so that's that. The other thing I just wanted to ask for clarification is when information and discovery comes from the NYPD to the prosecutor and then to the defender, is it true that there are things redacted from that evidence? And if there is, can someone explain to me why that would be?
Do you want to take this one, Julie? I mean, are you asking when it comes from the NYPD to a DA or?
Yeah, I was going to ask for that.
And then from the DA to you, I don't know if then that happens.
NYPD does not, NYPD does not send us redacted information.
So you get full.
Yeah.
Yeah, okay.
So the redactions happen after the ADA reviews it. And either there's some opportunities for redaction, but in general, there does need to be an application for a protective order on certain information. They ask the judge, hey, I need to hand this over, but it contains X, Y, and Z sensitive information. Can I redact it? And the judge determines, they might look it over themselves. They determine if we can redact that information, and then it is turned over. But we do not receive redacted information.
Okay, so the redaction happens in the district attorney's office, and I'd love to hear from Callie about that. And when it gets to you, and you're concerned about what potentially might be redacted, because I'm thinking there is a concern.
Yes, it's a huge concern. So that was one of the bigger.
Thank you. I'm sorry, Julia.
Oh, no.
Thank you.
Sorry. That was one of our big concerns with the proposal, because currently, Julia is right. There are very few things that they're permitted to redact without seeking a protective order from a judge. So at least the judge has to review it, right? They can redact like tax ID numbers and social security numbers and physical addresses of civilians and the names of certain types of witnesses and confidential informants, things like that, already without a protective order. That's the current law. Otherwise, they have to show good cause to a judge. One of the governor's proposals is to allow.
Justify the protective order, please.
Yes, of course. Thank you. A protective order is just basically a judge issued order that does what Julia was explaining, which is they say, yes, prosecutor, you may redact or withhold X, Y, and Z, either parts of a document or the full document based on the good cause that you've demonstrated in your application. So a good example might be if, it's like a serious case in an ongoing investigation and there are multiple players and like, let's say there's gang involvement and the prosecutor says, I don't want this person who's involved in, who's accused of this crime to know about the ongoing investigation that might implicate others who haven't yet been arrested. That might be a legitimate basis to withhold the material, right? That's just one example, but that's the kind of thing that they can do. They can also, if the victim is scared of the defendant, they don't want to be known, and they have specific reasons for that, they can also make that application. The problem is that what the proposal would do is in addition to increasing the number of sort of automatic things that they can just redact, like tax IDs and social security numbers, it would also mean that they can decide, oh, this part of a document isn't relevant to the defense, I'm redacting it. So, which honestly really doesn't get it. And the thing that upsets me more than anything about that proposal, in addition to the fact that it has potential for real abuse, not every DA will abuse it, but it has the potential to be abused in this sort of statewide law that we have. But also, it basically is exactly what the reform sought to prevent, right? That kind of discretion in the hands of a DA to make the decision of what's relevant for the defense and what isn't. They can't know that because they don't know our theory of the defense. They don't know what our client has told us, and we're not required to divulge that because it's privileged. And, you know, if we, and also, if they're the main reason that they argue that they need this law changed is that these dismissals are happening, that it's disproportional, as Julia was saying a moment ago. And the problem is, if you have the document, once you have the document in your possession, nothing is preventing you from turning it over, and you can avoid the dismissal. You can also move for a protective order if you have a reason you want to withhold it. So this notion that it's connected to this concern about, you know, cases getting dismissed left and right is silly. It's like, if you have it and you have it unredacted, there's no need to have this change made so that you can just redact more, right? That speaks to a different motivation.
Can I just follow up? 'Cause I just want to be I want to understand this clearly. You're talking about additional power for the district attorneys to redact at will, or do they still have to go to the judge?
At will, without a protective order. That's in the press. That's in the governor's proposal.
So, and just to be clear, currently we can redact tax IDs and social security numbers, but that's it. Everything else we need a protective order for. So a big part of what's in the governor's proposal that's important to us is, so I'm just going to take one step back, and again, stop me if I get too in the weeds. Under this discovery law, one of the additional changes is that prosecutors needed to turn over, I forget what word is, but sufficient contact information for all of our witnesses.
Adequate.
Thank you. Adequate contact information. However, beyond that, we need to get that protective order. So
it doesn't require physical addresses, Julia. It explicitly excludes them.
Not as it's currently written.
245-21C does explicitly.
245-20.
Check it. I'm telling you.
I'll believe you on that. But that there are other instances where there's contact information, like maybe not physical address, but let's say, you know, we're turning over a cell phone number, but like we don't want to turn over the home phone number or a work phone number. I don't think anyone has that anymore. For those additional contact numbers, we would have to ask for a protective order.
Okay.
So a big part of that part of the proposal is to try to save time, because judges generally are okay with us redacting that. So to save the time needed to, you know, do that protective order process.
Okay, thank you. Steve has a question.
Yeah, I mean, I'm having still struggling to find common ground here, and I guess the one area where it's coming down to seems to be where the judge is making the decision to dismiss the case, and that's what the DA's office wants to kind of go back on. But what I'm having trouble with there is basically the DA's office is saying too many cases are getting dismissed because of all of these discovery things. Okay, but ultimately, as Gloria mentioned, the judge is making the decision. So ultimately, you're not liking the decision that the judge is making. So you want the law changed to force the judge to make a decision that's more favorable to the DA's office than otherwise would be the case. And I'm having trouble understanding why we would want to take the decision-making away from the judge, who ultimately is the person who's looking at the entire body of the case. And you know, look, judges are not infallible. They're bound to make mistakes, and maybe cases get dismissed that shouldn't have been, but you know what? That's kind of the way the system works. The judges.
And also just note at our last meeting, we spoke about People v. Bay, and it seems like both sides would like to see that codified. But Andy's concern was that a lot of judges are either not familiar with it or are interpreting 245 incorrectly.
Right. So that's something that we've talked about a lot, that Bay says that the evaluation of whether a prosecutor has acted with good faith and due diligence is to look at essentially the totality of the circumstances. However, what we're seeing is certain judges look at whether we've exercised good faith and due diligence on an item by item basis. And that is often leading to a determination that we haven't. Again, like I'll go back to the example of not knowing that an officer was on scene, so not having their body worn camera footage. If we've gotten everything else and we've exercised good faith and due diligence, we couldn't have exercised due diligence in getting something we didn't know existed. It's simply impossible. If you don't know it exists, you can't look for it.
One quick, I'm sorry, I didn't mean to interrupt you. Go ahead.
Okay. So that is why we want there to be a clarification of the Bay language in the statute so that it's not something that's potentially misinterpreted or interpreted in a different way, because judges are able to interpret the law as long as if it's not explicitly written. So we're looking for it to be explicitly written. And when it comes to the question regarding, and I apologize for fading. When it comes to the question about the judge's discretion with dismissals, the governor's proposal, and nothing that we are supporting, takes away a judge's ability to determine that dismissal is the appropriate remedy for an error, a delay, or some sort of mistake. What we're saying is that certain judges are looking at the 3030 language and saying, while I believe that under 245, discovery laws, I could have looked at all these other remedies. The fact that the speedy trial clock has elapsed ties my hands so that that no longer is something I'm able to evaluate. And instead, looking at 3030, it states, if I am invalidating the COC, that means that the speedy trial clock has continued to run. That means that the speedy, based on whatever day it is, that means the speedy trial clock has elapsed. And thus, I have no choice but to follow that law and dismiss this case. That is what we are seeing. Not every judge in every situation, but we are seeing judges making that determination. We're seeing it in writing. And while I wish that I could share all the decisions that I see with you, there is issues when it comes with cases sealing because they're dismissed, so that I don't have that ability.
Okay, Cal is not going to agree with you.
I really can't, because it's a misstatement of the law. And I agree with you. There are judges who misinterpret Bay, and I'm fine with the codification of Bay. It's the law. It's the Court of Appeals has said this is the law, right? The factors that are basically this Court of Appeals case said, these are the things that judges should consider in evaluating whether there is due diligence. The Court of Appeals also made it really clear that where a prosecutor hasn't been diligent in their attempts to obtain discovery or to learn about it, that the case, it's not that therefore the case gets dismissed. It's that the prosecutor can't be deemed ready for trial. And if they're out of speedy trial time at that point, the case can get dismissed. If they are out of speedy trial time, when the prosecutor has not been diligent, and when they have filed their certificate of compliance, then yes, they are required to dismiss as a consequence of their failure to be ready for trial, because it defines readiness for trial as being diligent when it comes to discovery. And so the reason I got upset, and I apologize, but is that that's just an inaccurate. I've read the decisions you're talking about, Julia, and I understand that your office disagrees with many of the decisions that have been rendered by individual judges in Manhattan Criminal Court. And I'm sure your office will appeal many of those decisions, and as they should. That's the process. And we'll see what the appellate courts do when they, interpret it and they compare it against Bay and say, did the court do the right thing? I mean, this is part of how a law gets worked out, right? You have to give it time to live and for judges to interpret it and for the appellate courts to say, this is the line for the trial courts. But the problem is that what you're talking about is two totally different things. What was fundamental to Khalif's law, which is the law that we're talking about repealing essentially with this proposal, was the connection between speedy trial and discovery compliance. If we say to a judge, you can, in making a determination as to whether the prosecutor was ready in terms of their compliance with discovery, you can decide based on an evaluation of prejudice. Let me explain what that means. That means that the court not only has to say the defense had experienced a specific harm because of the delay in the production of this evidence. So it might be a year into the case. The defense is just now getting whatever evidence, fill in the blank. I haven't yet started my trial, right, as the defendant. I would be speculating at this point to say how I was harmed, even if it was a serious piece of evidence, even if it was the 911 call and the, surveillance footage. I don't necessarily, because I haven't yet started my trial, have a way of explaining to a judge how my trial has been irreparably harmed, how the outcome of my case has been irreparably harmed by their failure to turn it over when they were supposed to within 30 days of the case beginning. And here we are a year later, I can't really give the judge a specific way in which I was prejudiced. And that's what would be required for them to impose a serious consequence. So what a judge is more likely to do is what they did under the old statute. Because to be clear, in the blindfold era, the thing we needed to get away from that motivated these reforms, that prejudice was the standard. That's what they want to return to. So the prejudice will then say, okay, the judge has to come up with a proportional remedy. The proportional remedy, 9 times out of 10, is going to be an adjournment. It's going to be, okay, the defense gets more time with the discovery. I'm ordering you to turn it over, prosecutor, and the defense gets more time. So what does that mean? It means you end up with more Khalif Browders, right? You end up with people who are sitting in jail for 3 years, or who, even if they're not in jail, are waiting for their trial for 3 years. And the problem is, you might think like, okay, prejudice, we're talking about harm. That should mean the delay itself, which could cause harm. The problem is, though, the prejudice that comes from the delay to the person, to the human being who's being charged with a crime and hasn't been proven guilty yet, that doesn't get considered. That's not part of the court's evaluation of prejudice. So the fact that I've been sitting in jail for 2 years without the access to my information, that's not a part of the judge's consideration. So that was what motivated this. That's why we needed this, because we could not have this endless cycle of like, I'm missing this, I need that. And if I can just I don't want to keep talking. I just want one more quick thing I need to say, because I think this is and this is not specific to you, Julia. I'm just saying this is a common thing I hear from every ADA making this argument, is that this notion that like, oh, the 6th officer who shows up to the scene and that's the thing that's causing these cases to get dismissed. Like, I think at our last meeting, Andy even agreed, like, body-worn camera is not the issue, right? They're not having a hard time tracking down body-worn camera. And to be clear, they shouldn't be, because any time that we raise an issue of discovery missing, it's because we reviewed the discovery that was turned over to us over the course of 90 days. And in the 2 weeks that we have to review it before we have to bring it up, we were able to determine, without access to the witnesses, without access to the NYPD, just knowing how these cases work and knowing the paperwork, we're able to look at it and say, wait, I'm missing this, and this. Shouldn't a prosecutor's diligence require that they look at the evidence that they're obtaining and that they make that determination, right? The way I learned that the 6th officer is missing is by watching the other officer's body-worn camera and recognizing that there are 8 officers at this scene and I only have 7, right? Where's that officer's body cam? So I just wanted to paint a little bit more of an accurate
So, so Julia, any common ground here? Would you concede any of that? And you're muted, so, we don't hear you.
Sorry. One thing I did want to point out, I don't think that when Andy said that, what he said about us being able to get body-worn cameras, I don't think that that was necessarily in the context of saying that we don't that we don't believe that cases aren't getting dismissed for our failure to turn certain things over. I think that he likely said that in a different context, more likely to do with the Myrie Lasher bill, but I wasn't there. I can't speak to that. What I think that we may have common ground on is that when something like, as you said, the surveillance video or the 911 call, if we don't do our due diligence to get you a 911 call and turn that over in a case where it is truly meaningful for the case, I don't think that there's any prosecutor who, in good faith, is going to stand up and disagree with a severe sanction up to and including dismissal. I think that the issue that we feel and is that when it is something that is not so serious, when it is something that is duplicative, that has information on it that is basically identical to another piece of paper that you did receive, that it's not fair, especially when there is a victim or a survivor in this case, that the case is dismissed, that they don't get their right to come to court, have their day in court, have their voice heard. I think that, and I know for a fact, Andy has said this multiple times, that he wouldn't feel comfortable spending his nights coming and speaking to defend what the law used to be. And I agree with him on that. I certainly wouldn't be, losing my voice over it. But we have seen the pendulum swing so severely in the other direction that we're looking for there to be that proportionality. Give the judges the chance to make that determination. Give the judges the tool to decide what is fair and appropriate and right for justice, for the community, for the system. And currently, the way that the law is written, if challenges were brought sooner, then they would be looking at 24580, and they can look at the list of choices. Callie, it is true. If challenges were not brought after the speedy trial clock has run, then 3030 wouldn't be part of the equation.
You don't file your COC till 85th day. That's what's going to happen. That's what happens. You don't practice anymore, Julia. I'm sorry. That is every single case. I'm sorry. I apologize, guys, but this is like, you have to understand that you cannot file a challenge. The defense cannot file a challenge until the certificate of compliance has been filed.
I understand that. I understand that.
They don't, if you look at the data, it's available. They do not file certificates of compliance in cases with more than 10 days to spare on their speedy trial clock. When you do that, you don't give the defense, and then they complain that we have delayed the case when we file a motion within a month, and that it's our fault that they're being charged with additional time when then the judge says they weren't diligent in the first place. So the problem with this is that you're confusing the two standards, Julia. That's the one thing I cannot let you do. The notion that we don't file speedy trial motions until the speedy trial clock has run. That's true. That would be ridiculous. There's no basis for a speedy trial motion before a speedy trial clock has run. However, 24580, which is the statute that deals with sanctions, does not require a motion to be filed, first of all. So there's no need to file that motion. But second of all, sanctions are driven by prejudice. Their judges do not impose sanctions because the prejudice standard does not work in terms of actually having a meaningful difference. If I file a motion, or if I were to ask for a sanction based on prejudice, which is what's in the current statute, at day 85, after the prosecutor files their certificate of compliance on a misdemeanor, the judge would say, okay, I'll adjourn the case for them to finish complying with discovery, because that would be the proportional response, according to the judge. And I know that that's what DAs want. That's our old system. That's preferential. But the problem is that that means that we don't have incentives, meaningful incentives for prosecutors to comply. So while I'm not casting aspersions on you, ADA Foreman, we practice together. I'm not, that this is not about you or any of your colleagues specifically. The problem is we all know that there are bad prosecutors out there, and even those who aren't bad, right? Who just have too much work. And the bottom line is that if you don't have a system that actually has a meaningful consequence attached to it for not doing your job diligently, then, and because that is what the governor's proposal says, even if you're not diligent, the case will not, you will not have your statement of readiness invalidated. Your case cannot be dismissed unless there is such significant prejudice, which again, I can't even show in those severe cases. So it doesn't matter if you agree that it should be dismissed. I won't be able to get the case dismissed because the judge will not find sufficient prejudice because it's my burden to make it out. So I am saying there is no, under the governor's proposal, there is literally no ability for a case, even if a prosecutor, literally it says, if the prosecutor is found not to be diligent, you must still find that there is prejudice to the defense based on the belated disclosure. And that's not about how severe how significant the evidence was that wasn't disclosed. It's about whether I can establish how I was harmed or my client was harmed at that
So
moment.
just to ask, and again, I'm not the governor, I'm not the senator of the assembly, but let's say it was changed to instead focus on the impactfulness of that evidence on your case, not using the word prejudice. Do you agree that then having judges look at the series, I can't even think of the word that I'm looking for, but the
Nature of the
how
evidence,
impactful each piece of evidence was
the nature of the
that
evidence
was missed?
is relevant to whether the prosecutor was diligent. And that ultimately is what the court should be considering. Because if you change the standard to be about how, no, because even if you change the standard to be about the harm caused to the defendant, because ultimately that's what it's about, right? How significant was this to your case? So how much did it impact you that it wasn't turned over at this point? The problem with that is, again, it's not that in that individual case, my client would otherwise have been found not guilty and now they're being found guilty. I can't make that case determinative, like showing in every case. The problem is that if you set up a standard that focuses on that, there will never be a dismissal, which means that which means the incentive scheme for prosecutors' compliance goes away. And the problem again with that is that you and I both know when we started practicing in 2012, there were rules around timing of discovery. The rules were that within 15 days of my demand, which had to be filed early in the case, prosecutors were supposed to provide discovery. I would be getting discovery 3 years down the line. We'd have misdemeanor DWI cases that would last 2 or 3 years, and I still wouldn't have the discovery. And that's because there was a system where the only incentive was a sanction that was proportional to the prejudice to the defendant. And I had to prove that prejudice. And the delay itself wasn't prejudice. The fact that I couldn't investigate my case wasn't prejudice. So the concern I have isn't that the remedy isn't proportional, isn't that like, if you give me one specific example where they comply in every single way and they fail to turn over one piece of paper, that case should be dismissed. And I'm dug in about that. It's that if you don't have a system that prevents systematically that kind of backsliding and that kind of, disregard for the rules, we're going to be back to where we were.
Okay, so,
I
Julia, we
Yeah.
are a community board. We're probably not going to rewrite the law. We were asked to support a resolution, by the DA that would, as Callie would express it, roll back the law to 2019. You can see that there is some skepticism here at the committee, but there's also some compassion for your position. Is there a way that you would, and just to find common ground, I think we're comfortable passing S613. It seems that the related and relevant may be a compromise that you would be willing to concede. You would like to see People v. Bay codified, so that we agree on all of that. The concern of one of the proposals was to change the standard that for the evidence for which prosecutors are responsible to that which is in their actual possession as opposed to constructive possession. That sounds like a real problem. So is that
So I just want to
something?
clarify that. I saw that in your email. That language has always been coupled with after the exercise of good faith and due diligence. So the idea behind that was we have to do everything that we can to identify, locate, gather, and possess things. And once we do all of that, that is what is in our actual possession. I know that there's been a lot of conversation back and forth on that language as well. So I don't want to like dig in so strongly, but I do want to make sure that it's made clear that we're not saying like what used to be discovery in what Callie is referring to as the bad old days. It really was what I have in my file is what I'm going to turn over. And if I didn't get it, I didn't get it. The way that actual possession is being used in the governor's proposal is tied with after the prosecutor exercises their good faith due diligence to collect everything that is enumerated in the 21 categories of discovery, which is not being changed. All 21 categories are remaining intact. That after everything is done to collect all of that information, people
Why
can
would,
turn it. I'm sorry.
would constructive possession not be satisfactory to you? I mean,
The issue is
because
in
we're
the
not,
circumstances where
the
I'm
idea
sorry?
is not to punish the prosecutor. The idea is that the state that's prosecuting a defendant is responsible collectively for handing over all the evidence.
Right, and a prosecutor's obligation never ends. You know, even once we file our COC, we do still need to keep an eye on things and make sure that things, you know, we make sure that if nothing new is generated. For example, in a lot of domestic violence cases, you get home visits where there's additional paperwork that is generated, that is in our constructive possession, but it's continuing to be generated. So after we file that COC, we still need to make sure that we're staying on top of things, getting all of that additional paperwork, making sure that we're getting any additional statements from our victims. The idea is once we have done our due diligence, once we have what we have from those 21 categories, we can file our initial COC, we can continue our obligations, but the fact that we turned everything over and then continue to get more or are made aware of more than we knew at the time that we filed the COC, that it would not invalidate that initial certificate of compliance. Excuse me. So I think that the language needs to be looked at as a more holistic, like the entire section, as opposed to just the clause of actual possession.
Okay, to what extent do both of you think that if we had better technology and a more efficient police department that was more willing to hand everything off to the prosecutor, that a lot of this would go away?
I mean, I think it's easier for me to address this probably than it is for Julia.
I, I don't agree that that would solve the problem. I think that it would make things easier. I think it would make my colleagues free up a lot of the time that they spend actively looking for things. They could spend that time investigating the case, speaking with their witnesses, investigating alternatives to incarceration, trying to get higher participation in those programs. Unfortunately, because so much of our work is now focused on this paper chase, and so much is focused on making sure that we have everything to avoid a dismissal.
So that's
It would free up some of that time. It would make the work of a prosecutor a little bit broader, but it would not solve the problems that have been caused by the reforms from 2019.
It sounds like it would get a lot closer though, wouldn't it?
Yeah.
That seems to be.
We don't agree with that. No, we believe that that helps with one facet of the issue, which is the collection. We don't agree that it deals with the issue of the cases being dismissed.
How
But
would
isn't that where the judges come into play that we talked about earlier? Like,
Well,
it's
keeping
the
in mind
judge-
that NYPD documents are only one portion of the discovery that we need to collect. That's not everything. We have to go to other agencies. We have to go to individuals. We have to go to private businesses. There is a lot more that goes into the discovery than simply getting documents from the NYPD.
But it seems like there's such a long lapse to get those documents. And what would you change if you could change this system within the NYPD reporting?
Well, within that, it's why we're supporting Zellner, Myrie, and Michael Asher's bill. We agree that that would solve that part of the issue. We don't believe that solving that issue is all that is needed to avoid the severe increase in dismissals that we have seen happening since 2019.
But again, that goes back to the judges, right? And it's because a lot of the judges, and it's just according to the last meeting, a lot of judges are unaware of the decision from people we pay. So instead of undoing all of these, why not spend time or resources in either codifying that or educating the judges? I mean, medical profession has CE, like continuing education. Don't lawyers have
We do.
anything similar?
Of course we do, and that's why we both agree that codifying
also-
Bay is necessary.
So
But it
once that's
also-
codified and judges are more like aware of this, that should also bring down the dismissal cases, wouldn't it? Like-
Partially, but as long as judges believe and are making decisions based on the 30/30 statute and determining that there is only one remedy if the 30/30 clock has expired without every single shred of paperwork being turned over. If the only remedy is dismissal, and I'm sure Andy has said this numerous times, that's only happening in New York State. There is no other state where discovery, omission, or delay that does not affect someone's constitutional rights results in a dismissal. It doesn't happen anywhere else other than New York State. So what we're saying is, let's make sure that yes, our feet are held to the fire, that we don't go back to the time where, discovery was turned over on the eve of trial. But that we do need to make sure that dismissals for irrelevant or duplicative documents, which is happening in every borough. I can't speak to every county because frankly, I haven't been to all the counties. But that this is something that is affecting thousands of New Yorkers every single year. Let's make sure that we're not just playing this game of they missed this one piece of paper, the case is dismissed. And let's make sure that the judges are given every tool in their toolbox to determine what is right and appropriate. And let's see cases actually decided on the merits, on the evidence. Let's see, testimony and a jury getting to hear from both sides and hearing cross-examinations. Let's, make sure that we're not just harming the survivors, that we're not, harming our system by allowing dismissals based on, as I said, irrelevant and at times duplicative information not being turned over, end a case.
But I think what Callie would say, which we could probably ask her because she seems to be here, is that first of all, the proportionality does exist in 245. So under People v. Bay, which could be codified, judges would apply a proportionality standard. And the concern is that when you get to the point where you hit the speedy trial deadline, if you just keep extending that, it's pretty unfair to the defendant. And it seems like you have, it seems like you had sufficient time under 245 to collect the evidence and to submit it. And if you then still run into the 30/30 clock, then maybe it's time to dismiss the case. So how do you respond to that?
I respond to it that you
Give
can't
me
have
a- Give me a hand. Did I do that well? Is that what you would say? Okay. I'm sorry. Go ahead.
I would say that, and I know that, as Callie says, and has quoted Bay. I've heard her quote Bay in other meetings, that the law does not imagine a perfect prosecutor, but unfortunately, that is what we are seeing. Things slip through the cracks. I don't agree with Callie that the judges are just going to give more time and more time and more time. I think that that's just something that we're not going to agree on. I do believe that judges will look and decide, all right, well, let's again use the example of the injury photos. The judge can say, people, you can't use that photo, no matter how good it would, it would bolster your case. It's great evidence for you, but you didn't turn it over in time, so now you can't use it. Or if it's something, maybe we didn't turn over several photos, maybe the judge decides that there's something, that he doesn't want to outright dismiss the case because all the every piece of paperwork was turned over, but not these photos. Maybe the judge decides that what's appropriate is that we'd get an adverse inference, meaning that the jury is told, the people had photos, they didn't turn them over. You can draw a negative inference from that failure.
Okay, so that's good. Committee members, do we have enough information to assess how we feel about, first of all, the prosecutor's proposal, the Danny proposal? Do we have more questions? Are we never going to be sophisticated enough to answer that? How do you guys feel?
I'm not in support of the DANY's proposal because they basically support governor's proposal, which essentially would make the prosecutors the gatekeepers of what to deciding what's relevant and what's not relevant. And as Gloria said earlier, our system puts each other against each other. So the prosecutor's job is to get a conviction. If they feel like some information in there is gonna hurt that chances, they might feel like, oh, it's not relevant. That's the one thing. The other thing is the whole constructive versus, what was the other one?
Actual.
That one. Okay, NYPD, you have all that information. If the prosecutor, again, it goes back to, I have to win this case, I have to get this conviction. But I know there's somebody out there who might dispute my side of the story or my theory on this case. I'm gonna make an attempt, maybe I'll reach out to them a couple of times knowing they might not be there or I might not reach them, but then show, hey, I made a good faith attempt. I tried 3 or 4 times and then not really do it. I just feel like there's a lot of potential for abuse in that proposal. And I would not support it.
Gloria, do you have any thoughts you want to share?
Yeah, well, 2 things. One is the change in the law has not been that many years. And I think I have a couple concerns. I have a concern about a potential governor that's politicizing crime and trials to get reelected. Okay, okay, I'm not saying it's true. I have a concern. This could be a motivation. The second thing is you have a change that was just made. I mean, I don't know. Is everyone 5 years old here? Like 5 years is nothing in trying to see how well the current changes are doing. So this rush to kind of change them now, and also we went through COVID through most of that. Okay, so I don't think the data is accurate, right? And I'm not saying that the DA doesn't have a point, like they have lots of points, and the data could bear that out in more time. I don't see why we're rushing. I could never support doing this. It feels not right. And if I was accused of something, I want to know every single thing they have that they're accusing me for. And I think most people would want that too.
Yeah.
Stephen, you have an opinion?
No, I wouldn't support the DA's proposal.
No, I didn't either.
Justin,
I support it.
speak.
I feel like the number one issue that I see when I go on places like Nextdoor, just talk to people in the community, is a pretty common theme of feeling that the city has grown significantly unsafer over the last few years.
On what?
Unsafer in the last few years.
Safer?
Like less safe.
Unsafe, yes.
And I feel like there are too many dismissals happening. And that I respect the position of the Legal Aid Society, but I think that the laws that were passed I understand why they were passed at the time. But I think that this is a correction in the right direction.
Can I
Okay.
respond briefly, please, Stu?
Of course.
I mean, I wish people would all go on to the NYPD site of crimes. And actually, I mean, this is my issue with the governor. If you go on, most areas of crime are on the decline. We are actually more safe. So we really want to be careful of what we hear and listen to and what is fact. I'm telling everyone to go onto that site and look at the truth about what's going on in the city. So I just think everyone should do that. Let's, so that's it. That's all I wanted to say. I'm out of here.
What else, my response to that would be, the reason the governor is putting forward this position is because that's a sentiment. In other words, you're right, you're probably right, or you could be right in the sense that it could be a political opportunist perspective, but the reason is because that is the current sentiment, and so she's playing to it. And I think my position in representing the community, when I see a very vocalized sentiment online, feeling that, or just in general feeling that way, I feel like it's gone. I respect the legal aid's position, society's position, but I feel like it's gone a little too far. That's my point of view.
Do either, I guess, of our legislative offices have any comments that they want to share with us? Wendy or Peyton? You don't have to.
I don't. I just want to say that Senator Krueger supports us. Well, she supports the intent of 613. And she wants to make sure that neither side, the prosecutor or the defense, has an undue advantage. But that, this is being negotiated right now. So Senator Krueger's a little cagey about exactly where she stands on this at the current moment.
Okay, and Peyton, if you want, please pipe in, but I don't see your picture, I just see your name, so I don't know if you're here.
My camera, it says my camera is on. If it's
yes,
I
now
see
we see
Peyton.
you. There you are.
well, I don't have much to add. I just wanted to say thank you for inviting our offices to this conversation. It's been really valuable to hear this. So thank you.
Okay, so the general sentiment here is some degree of skepticism about the DA's proposal. But Julia, are there concessions that you might make that would be sufficient for us to support something? So you do both support 613, you do both support codification of Bay. There is some common ground, but it doesn't, it's not really a motion to change the discovery law, but just to make, to add a few other provisions, basically. Is there anything that you would concede that might persuade us to support the DA's proposals?
I don't think I have the authority to do something like that. I would suggest that, wow, it's totally gone. I would suggest that if there are parts of the proposal that was sent that you want to support, I know Eric is on this call, could be in communication with you guys on that, if that's something that your board wants to do, to modify what was sent. I think we could talk about that in our office tomorrow and maybe get back to you.
Okay, and Eric, we recruited as Andy's understudy last week. So Eric, would you want to add anything? And again, you don't have to.
I don't think so. I would just echo what Julia said. If there's any other, if you wanted to, Stu and the rest of the committee, to go through and pick out things that you would support in that sample resolution that we sent over, that we can bring that back. We're more than willing to work with you guys to basically adjust it accordingly.
Okay, and understand that what we could end up doing is supporting some of it, but actually actively opposing other parts of it.
Yeah.
So that is a possibility. Does the committee or anyone have any other questions or statements, or are we exhausted? None.
Learned more in the last hour about
It's-
trial procedure.
Right?
So,
Wow, amazing.
it's really impressive.
You guys, no, I
You
just
guys
wanted
have
to,
done great work.
yeah.
So
amazing
I think
work they did.
that this has been a very healthy discussion.
Mhm.
And we did come into this without certainty. You've all certainly educated us. But you can see the direction of the sentiment here right now. I think we would welcome further communications, if either of you, wish to, or any of you wish to suggest a direction that we can go. At this point, though, our options would be, probably to do nothing or actually to oppose, the governor's, motion. Justin obviously will disagree, but
What about putting a resolution forward to support certain parts of it?
if you
Yeah.
would like to, I mean, again, considering what you've heard here,
Yeah,
if you think you can find a compromise, or
yeah,
the third
definitely.
way.
No, I'm not, I mean, I'm very, like, this is one I don't wanna, I wanna vote yes or no, and I don't wanna vote abstain on it, and I'm leaning towards yes, but I'm not, like, I understand Legal Aid Society's arguments too, so if we can, if there's some things that we could support, I'm not, I don't feel like everything needs to be supported in the resolution. Or
Okay.
in the governor's bill.
So why don't you, draft, a reso, and it will be open for discussion next month.
Okay.
We all good with that?
We can come to some common ground about stuff that we do support.
Okay, we've kept you all up. Interrogated you for more than an hour. And Julie, especially, I'm really sorry about your voice.
Yeah.
We want to hear what you sound like when you sing, and obviously.
Oh, no. Oh, no, you don't. It might sound better now.
Yeah, we'll be the judge of that.
All right, karaoke, community board sticks. I'll be there.
Thank you all very much.
Yeah, thank you.
We will
Haley.
continue to have discussions here. Obviously, we're not coming to a vote, probably not next month. But we did take everything that you all said, you can tell, quite seriously. Anne, who's not here, I'll speak for her, was also really intrigued by this. But I don't think we have a place that we can go with it right now. So thank you all, and we're gonna move on to our next agenda item. I'll wait.
Can I just
So
ask
much for having us.
if I need some support can I email them, or or email, I don't know, like, how that usually is done.
I don't know, we'll discuss that, because it's you're having a direct communication with them, but you're not allowed to do that
Yeah.
as an official with the board. But we're not having, it's not, we won't have a quorum when you have a talk,
Sure.
so we can discuss how that can be done.
Yeah, we can work that out.
Okay,
Maybe we could
we'll,
have everybody on the.
we'll have some way for you to communicate. Because we want to, we care about the law. Thank you very much.
Yeah.
Yes,
Thank
we
you.
do. We care about the law.
Thank you all. Have a good night.
Appreciate it.
Thanks, everyone.
Thank you, Peyton. And I think that's everyone who's left. We are gonna move on to the next agenda item now.
I was gonna use the restroom, that's what was too kind.
No, it's, first of all, you can feel free to rest anytime you want. But we don't want to insult Steve, who along with Anne has drafted the, reso that we're about to discuss. But you can move to take a 5-minute break. Would you like to do that?
Yeah.
We're gonna return for 5 minutes. No vote is necessary.
That was very interesting. I'm just here because I want to learn stuff like that. So,
Well, we all learned
it was very.
the concern
I'm
is.
concerned with, but it sounds like it's already being negotiated in Albany. I read between the lines of what, Senator Kruger's.
Well, the governor has written, as part of
Right.
the budget, has written, a proposition.
Yeah.
But that doesn't mean we have to support.
No, I
detail
know.
of it. And,
Just wondering where that all stands, I guess, but, it was about, I learned a lot from the discussion. I also learned that you can't replace that kind of dialogue with AI. You know, which I was reading recently, Bill Gates was saying that you could, that was really
Thank
very,
you. Thank you for
very
being here.
You're
powerful.
right. You are so right.
Me?
Yeah. I mean, I
Right.
didn't even think about that, but yeah. As always, John.
Well, once AI is here,
Hmm.
once AI is here long enough, people won't be able to have that kind of discussion. That is the problem.
Yeah.
One thing to be able to keep in mind, by the way, the mic is,
I'm gonna rest, but I'll be right back. That's the point.
So rest is a euphemism, right? Laura, you look very comfortable.
I'm in a hotel room,
Mm-hmm.
but I was starving and I don't want to eat on camera because this is all public. It's like, oh, watch her eat. It's not good. And I'm like, but I'm eating right now a little bit. Starving. I feel like Jim Acosta. Well, he's always doing shows from a hotel room.
Are we supposed to play music during the interim? I guess not. So let's unmute,
Yep, we're unmuted now.
and we are back. No music again. Steve, it's your turn. So the this
The
is
resolution is on the screen and I welcome your feedback.
I think it's very well written.
Want me to start the whereas clauses or the resolves?
Well, I'm guessing that everyone has had a chance to read it, since we're all on the committee and we've received it in advance. I can start by asking questions. Okay, sure. So, part of my concern is pretty simple, that this is just a very long resolution. Why is it relevant that several city agencies have basically contradicted the law department's advice?
It was taking one of the whereases from your original resolution and giving it the actual kind of saying which agencies had done that. Right, so that we're saying there's a conflict, right? Your resolution stated that Eric Adams was going against what? And so this was saying the what that Adams was kind of contravening with his January memo.
Oh, I'm sorry, I don't think that's what I meant to say. What I was saying is that he was by providing, well, we're talking about two different things. The first one is the current rule from the January 13th, right?
The New York City's law office's January 13th memo, which changed, which added that new interpretation, right?
Exactly, so
this was stating that whereas states what was the interpretation prior to the January 13th. And those are the two things that are in conflict, right?
Well, I don't know that that's a conflict. The city agencies may have rules that are inconsistent with the corporation council's advice, but the city the corporation council is sending out basically Eric Adams' proposition. And city agencies are subject to his orders. I mean, they're administrative agencies, so they can publish a rule that is at odds with the city's policy. But if somebody were to violate, if someone with the agency were to violate the agency's rules, but be consistent with the rule that the corporation council had put out, that person is probably quite safe. I mean, I don't think the city administration's rules precede anything that an agency can do. I'm just not clear why this is. I spoke very badly.
I think we're saying the same thing, right? Because then why have, I mean, that's the whole point of the resolution, right? You said in your original resolution, any employee now can decide based on this January 13th, but we don't want that.
Correct.
Why? Because there are agencies that have a your thing said, there's long-standing sanctuary policies in place from the city, which now Eric Adams has decided to do away with. And what you're saying is that's not what we want, right?
That's correct.
That's essentially what this is saying is there's city sanctuary established protocols. Eric Adams turned it on its head by saying any employee can decide I'm threatened and I need to let ICE in. So now we're saying we want to close that gap is essentially the way that I read.
I agree with everything that you just
that's
said.
what this says.
What this says is just several city agencies have instructed, have issued instructions that are contrary to the Adams administration directive. I'm on slide 23.
So you're saying Eric Adams' directive is in sync with?
No,
the opposite?
I'm saying that
City policies?
on line 23, please?
Maybe it's just a little
Yeah.
correction that needs to be made, like maybe it's just, you know.
It's,
The wording.
what you're saying here is that several city agencies are, have instructed their employees, to the contrary of what the Adams administration has directed.
But preceding, this was the established rules prior to the January 13th memo.
But that's not clear to me
Yeah.
from that, whereas.
I think I think it goes back to the conversation we had last meeting where you're like, okay, this is what Adam said, that we're going back on the sanctuary city laws. But then a lot of agency heads said, no, we don't have to follow it. And that's what I think that's essentially.
That's how I'm
saying.
reading this.
As in like, but then he's saying that we shouldn't have it that way, like, as in, like. Yeah, like the city agencies, like, yeah, so it basically what it's saying is that these two are in conflict with each other, so it's clarifying that conflict.
Well, but there isn't, yes, these are in conflict, but the mayor's, orders, supersede anything that an agency chooses to do.
So what is at the end of the day, I did listen to a fair amount of it, but you wanted a resolution for going against what Mayor Adams was starting to do, right? Or has started to
You want
implement.
to return back to the previous.
Yeah, and I'm
resolution
agreeing
to
with the
return back?
resolution, I'm just asking the purpose of this particular clause.
Okay.
But I'm.
I mean, we can clarify, I guess the purpose is for those of us who don't know, until I had to go read about it, right?
Yeah,
Like,
yeah.
this happened, like, this is what there's actually a protocol
So
that New
this-
York City
but
has
this
put
is-
in place
this is
for
basically the-
years.
I'm sorry,
Right,
this is basically the status quo ante.
Correct.
Um,
And without that, then nobody would know what is the status quo. You know, because then it just jumps from a January 13th memo, but okay, what is it? It wouldn't you would lose the link to.
So I would
We can
just
just-
simply say, up until January 13th, these were the rules and each agency, issued them.
Yeah, we can say whereas prior to January 13th,
Oh, that would be fine.
agencies have,
Sure,
okay,
You fix
that
it.
was.
Same thing, but
That's
Yeah.
just, I think it was
It's
just,
just,
yeah,
it's just tweaking
it's a
something.
tiny thing,
But
yeah.
let me ask you a question, is this still in motion, is this still in happening, is this, wasn't there a lot of pushback and they're waiting on?
And well, there's
What,
also,
he's
there's
gonna
also a
push this
question
further
now
back?
that Adams can no longer be prosecuted by the Trump administration. There's also a question of whether that quid pro quo exists anymore and therefore what his motivation would be. That's on the Rikers Island question, which has not yet been implemented.
Just a question, this suggested clause, where would it go?
Down. That's the
23
next
again.
one,
So
Yeah.
around here?
yeah,
So it'd be.
whereas, prior to January 13th.
That's all you were missing.
No, it's in the same
No,
clause.
same clause. I'm just saying add it to before this.
Oh, okay, so now adding of a clause.
No.
Whereas prior. Not all caps.
Who else is tackling this? Is it just us? Is like.
And then just say several city agencies
Community.
instructed staff, take out the have
Oh, I
to make it
I
grammatically.
don't know the
okay.
answer.
I'm just wondering how it landed.
Until
how
they
it landed on-
received
Oh.
past
That's my
tense.
fault.
Is it
Third,
Something's
no, line 25,
It was important.
Until they
received authorization from the agency's general counsel.
Okay.
Yeah.
But I'm
Yes,
just,
no,
you know,
it's-
I'm
yeah,
just
I think
wondering
it's
if,
correct
yeah,
grammatically.
you know, just like the bicycle resolution. Like, how much time we put into this? And when it's already being handled and it's other agencies are dealing with it.
Well, I don't think it's being handled and the agencies can't deal with it because Adams again can supersede anything that they order. And the concern here again, which you just expressed orally, but I don't think is in the resolution and maybe it doesn't have to be. is that what this rule change does is grant individuals the discretion to void city policy.
Yeah.
And that's a particularly bad thing. I mean, whatever you
Mhm.
believe city policy should be,
Mhm.
one way or the other, it should not be at the discretion of an individual, to simply say, you know, under the pretext of fearing, their safety from a federal agent.
The discretion of the
which
city
is,
individual?
I'm sorry?
The city individuals.
A city employee, yeah. What a city employee could simply say, I feared for my safety when this federal agent came, and therefore I will negate basically.
With no proof, like they don't have, they just
There's
on the
no,
vibes.
there's no requirement, to
Like-
explain, or to justify that. And it seems sort of incredible, and I think that if you were actually in a situation where a federal agent actually did forcefully, threaten, legally or illegally threaten a city employee, then, you know, we would not expect that employee to stand in the way, of an armed federal agent. But what this is saying is you don't have to worry about that. You just say you feared for your safety and
Right, that's it.
so I'm just asking, that language is not in here, and I'm wondering if it should be, because I think that's an important point. That, you know, whatever you believe the policy should be, it should be set by the city, and it should not be, something that an individual can simply say, I don't care.
That language sounded provocative to me unnecessarily. I didn't want to put something in there that people might object and want to vote against our resolution. And I think it places, we're placing motivation on a city employee, not understanding what their situation might be by assuming that, oh, I'm just gonna be rogue here. And, you know, the impression I get from that phrase is you're assuming a city employee wants to go rogue and just wants to let ICE in. But I don't know that that is.
Yeah.
No, like it could be the case, but there also could be, there are cases where Doge has showed up with US Marshals and said, let us in with guns.
Well, that's what I was
So,
wondering. It has happened.
I mean,
in
it
the
has
city, like,
happened.
it has
So,
happened in the city.
I don't want to say like, well, the only reason why the employee let them in is because they just wanted to let them in.
But
And they're claiming that they showed up with, and they
Right.
were maybe they were in fear of their life, you know, like, I don't know. I don't want to say, I don't want to presuppose what motivations city employees might have for not doing or maybe
But
doing
we're
something.
not
So, like,
necessarily presupposing an individual's motivations. We're saying that the change in law makes that a possibility. It makes it gives individuals, the ability to negate a citywide policy, just because they want to. That doesn't mean everyone who does that.
But right, but we could also word it allows them to advocate for saving someone's life in a situation that is threatening. That's also true, and that could be it, right? So like, that's where I kind of go back and forth, like, I get it, but I also don't want to call out, like, we're somehow painting city employees as like,
Oh, yeah.
I don't know that
Yeah.
it does that, but, if there's not a general sentiment that should be added, then I don't think it has to be. And I won't argue for it. Line 38, then, if you could go there. This is, small, but, committed no other crime. Actually, not all undocumented individuals have committed any crime. Overstaying a visa may just be a civil offense. So I would remove the
I
word
agree
other.
with that.
Yeah.
So permitted no,
Just get rid of other. We okay with that?
Yeah.
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 I think Pete, so I was trying to thread the needle. People who are against people being here illegally say they have committed a crime, they're here illegally.
Yes, but that's not a crime. It's not.
They have violated immigration laws, so it is a crime, right? So like,
It depends.
I don't essentially, again, I don't agree with that. But if you've come in here and you're not here on a legal status, that you are
It's-
technically
It's not a crime, no, it can be a civil violation, overstaying.
Yeah, well, you mean you're talking like a lawyer, we're just trying to understand as like people in the community.
I think it's.
And I don't want this
civic-
to have a big
civic
argument in
considered
front of.
civic violation if it's in. I forget which one it
It
is,
can
but it's
be a crime.
overstayed,
It
can
can
be.
be a crime, but it may also just be a civil violation, so I don't wanna put in here that they've committed no other crime when they may have committed no crime. Are we okay with that change in the language, or do we feel that took something away that we need?
I'm okay with that change.
I'm okay with it, just be prepared for someone to object at full board. If they read it and.
Oh, that's okay, they'll be defending it. And that same clause, for example, just seems unnecessary to me. I'm just trying to tighten up the reso, but I don't have a particular objection to it. I just think it's more than we need. For example, somebody stopped, detained, and charged with a crime.
Yeah. I'm good with that change.
You okay?
You mean, yeah, just taking out the for example.
And Gloria, we know you're far away, but we are looking at you.
You know, I think that it's important to actually, this is more important than ever now because we know that people who should never have been taken and sent to prisons abroad, and they even admitted it, happened. So due process is so critical here. So I just really want to err on the side of safety, and I'm good with this. I think it works. I mean, I like the resolution. It's written really well.
I hate to ask the other obvious question, like, how fast can this get through? Like, when would this get implemented?
I'm sorry, when
Would this resolution get implemented? Like, when would they just pass and, I mean, we're talking about things that are happening right now underneath our feet. So
Sure.
when is this gonna actually, would this get, what do you perceive, and when would this get into motion? If it did,
The city council would have to pass something.
yeah,
right,
but
we
we're
can.
asking, I mean, we're simply issuing the sentiment of the community in this case, and we are encouraging the city council to act. And, you remember we had this discussion when we were all younger, about, our resolutions having some effect and not just being, aspirational. I think that this is a case where it can have some degree of influence, if it's sent to our representatives, and if I'm wrong, it's not a bad thing, to express our sentiments here. And on line 46 and 47, Department of Correction, I think we should just say New York City Department of Correction. And is everyone else otherwise happy with this?
Yeah.
Justin?
I'm probably gonna end up abstaining on this. I still feel like some of the language is politically charged, or not politically charged, a little too charged, that first paragraph. But I also, I appreciate the changes, so I kind of don't feel comfortable voting either way. This one I.
Okay, and just know that abstaining is effectively a vote against.
I know technically it is, but that's not my, okay,
Actually-
literally it is, that's not the intent behind it.
you wanted to change, that would make it better for you.
I think that it comes off to me as being a little too, as I said, the full first paragraph. No, go up.
The first whereas, you mean?
Yeah, I go up a little bit more.
The very first, whereas,
Line 3,
That's fine. They don't do
line 3, right?
Line 3, like at the very beginning, is that what you were talking about, Justin?
Substitute policies, that's fine, institution. I find the 9 paragraph. I think it's a little too, it comes off to me as being like kind of leading towards the conclusion. In other words, I mean, some studies show that. I'm not sure that's true that all studies show that. I don't really feel comfortable agreeing with that whole paragraph. I'm not saying that's entirely false, but I'm not sure that that's true, and it comes off to me as a little bit, I don't know what the word is, it feels like it kind of, it makes the rest of the argument weaker to me, which I know the intent was to make it stronger, but if I was reading this, and I would just see it as being a little too, a little too politicized.
So what if it was left out? If that clause right there was left out?
We can keep going if that clause is left out.
But I think my problem with that is not so much that part that's saying studies show, is that one of the things we talked about at the last meeting was if they're in fear of potentially being deported, they could witness a crime and never report that crime, which is in that paragraph too. So I get part of that, like study thing. I totally understand that because, you might need more detail or I don't know, studies to show that. But that part I think is a very realistic potential situation.
Which one?
Because
The one
people are
that,
going to hide. They're not going to report crimes. They're not going to get involved, right? Even if there's a problem in the community, they're not going to want to get. You see this. It happens all the time. Everyone knows it happens.
Essentially, that is encapsulating why do you want to have sanctuary policies? It's because you want them to be able to avail themselves of the shelters, the hospitals, the schools, reporting to police. Like with all of that, it almost kind of falls apart. Like why are we?
I see.
I'm not really uncomfortable with the second part. It's really the studies part. I think it's just like, whereas studies have, if you want to include the interact with and report crimes part, that's fine.
There were 2 studies cited.
Well, you cited studies in
and
there.
one of them certainly was from a liberal or progressive organization. The other one, though,
Yeah, one was from Center for American Progress, the other one was from Urban Affairs Review,
right.
which is just a city.
And I mean, Justin, I have never seen anything that said that immigration is responsible for an increase in crime rate. I mean, I think the studies, and I'm obviously speaking off the cuff, but I think any study, the consensus is that people who are here as immigrants tend to commit fewer crimes or crimes at a lower rate. And there are some reasons for that, like they don't want to be deported, they know they're at higher risk. And there are other logical reasons for that as well.
I'm gonna bring up a kind of different alternative scenario I was thinking of, and just, hear me out on this. The Trump administration, I don't know if you've been following, but they are pretty intent on, I would say, reorienting where a lot of immigrants and refugees are coming from. So for them, like one of the big things has been having a lot more of the South African population, let's say.
White South African. White South African.
Yeah, African here, right?
Because we need more Musks.
Yeah. What I'm saying is that is a possibility that by having some of this in here, just in general, the resolution, the political dynamics change, and it could be 4 years from now, and you could have and I say, seen as a Jewish person, a more white nationalist group from those locations, that you're limiting any immigration enforcement against them. And so, the common perspective is there's people coming from countries and we want to support them. But that can work the other way too, where there are populations coming from places that were concerned, such as, the white South African population. And I would be a little, like, I'm just saying, in 4 years from now, the administration changes and there's no real way to have any immigration enforcement against that.
I don't think that this has any impact on that kind of a policy question, though. We're not trying to change immigration law here. We're saying whoever is here, as an immigrant,
Mhm.
and especially an undocumented immigrant, although documents now is a risk too.
Yeah.
Um, it is subject to these threats.
I'm just saying it puts a little bit of, what's the word? Handcuffs on if it's groups that might, you get white supremacist groups from whether Europe or other places, like, you don't know how that's gonna accelerate the next few years.
But how does this affect, I mean, if someone's arrested and convicted of a crime,
Mhm.
they can still be handed over to ICE, and that's not inconsistent with city policy. This is, there can be a federal warrant for someone, and that warrant will be allowed to be executed. That's not inconsistent with city policy. So I'm not.
How does that, but that's why, for example, that first sentence was safer, I'm not sure that that's always gonna be accurate. Like, I mean, if you wanted, that's why I'm saying it kind of makes the argument a little bit weaker, because that is a point of, what's the word? That is a point of, I would say, it might, it might not, in 4 years from now, it might not make the city safer. You're kind of weakening the argument by saying that. That's different than going back to, pre-January 13th.
So you're saying if all of a sudden, the bulk of immigrants were not here looking for sanctuary, but were here, to commit crime.
No, I'm not saying to commit crime, I'm saying it's not here to commit crime, it's that it's not like, you're seeing safer as,
You're saying, I mean,
Well, I think I know what Justin is saying. And your concern, listen, if we get a guy who's kicking out like just all these other people trying to get sanctuary, like their lives are in threatened countries, and all of a sudden we're letting in, because this is how this is moving, white supremacists or even Nazi from Germany, South Africa, and so forth, we're still saying this statement. But I think I understand all of that, but I think we're kind of have to be in the moment, because this is like a moving train,
Yeah.
right?
Yeah.
I mean, stuff is changing every minute of every day. And I think I totally respect what you're saying about that. But I think probably this is more like kind of reacting in the moment, because you know what? In 6 months from now, we might have to have another
Yeah. I think
resolution.
Yeah, and I think the resolution is just dealing with what's happening exactly right now.
Yeah.
And just dealing, it's not about the future, it's not about, it's what's there now.
We're talking about
Sanctuary
right
city.
now in this
And
moment.
in this moment, exactly. And so this is what this resolution is, like, just to stop what Mayor Adams had put out to these agencies or whatever, to just react to that right now. This isn't about what's gonna happen in what's gonna happen in the future. But it's to put this.
Yeah, it's a resolution is completely agnostic as to the mix of how many immigrants come in, if it's no more immigrants come in, it doesn't matter.
Yeah.
Where they come from. It's saying, how do we deal with the mechanics of when they're here?
Really, who's on the ground right now, basically.
Who is here?
Mhm.
Regardless of what mix they are, where they came from, the mix of countries they come from.
But do you see, like, thinking beyond the resolution, do you see what my point is about that, or is that kind of still unclear?
Justin, you're just giving me more stuff to worry about. I don't appreciate that.
Foreshadowing the
Yeah.
future.
You're giving me more stuff to worry about.
Build a case, and he's just trying to like put another, like a whereas with the backstory, like why there was, that this is true, there has been some studies about this. It's just backing up, as we put these resolutions together, the argument as to why we want it in, does it need to be there? I don't know, but I think it makes sense. It's just giving the backbone to it.
I think it makes the argument stronger.
Yeah.
Look, we've been on law all night, right? And we're just trying to make people actually follow the law and how you actually do deport someone based on a crime. And there's rules and they can do that. We know they have a process for that. We just don't want raids of innocent, potentially innocent people, which is what is happening, get sent out. And also just the trauma, I'm sorry, the trauma of this is huge, not just for those people, but their entire families and community. I mean, we are being traumatized every day. I don't even want to talk about where we're gonna have to go with trauma after this. But I think it's just basically say, I mean, we're just trying to say, we don't like quid pro quo here to stay out of jail. And you can't just change things because it suits you. And let's just stick really to what we've always done. Pretty
So
much, right?
is there any more that we can contribute or should we vote?
I move to vote.
Yeah.
I
Okay,
second.
and I will be very formal with Robert's rules. Someone want to?
I make the motion to vote.
Excellent.
I second her motion.
Yeah, there you go.
Hey, Brendan.
Okay,
There you
when
go.
I call your name, please say whether you're in favor, opposed, abstain, or not entitled. Stu Desser,
In favor.
Justin Goldberg,
Abstain.
Gloria Hay,
In favor?
Rupal Kakad,
In favor.
Steve Perez,
In favor.
and Michael Langro.
In favor.
With 5 committee members in favor and 1 abstention, this resolution passes.
What does not
Okay.
entitled mean?
I
Not-
know, I was just wondering.
You have a
that.
conflict of
too.
interest. It means you have a conflict of interest.
Exactly.
Oh, conflict. Okay,
Like
got
you're
you.
an employee of
Okay.
the city parks department.
Mhm.
Right.
Yeah, so
Yeah.
to give an example, we have a board member who
Yeah.
works at NYU. So whenever there are
Yeah.
any matters related to NYU that come before the board.
So that's the not
that
entitled.
board
Okay,
member- That board member abstains for cause.
Yeah.
So
Got
that
ya.
is.
got you. So it's abstain for cause.
Then if you abstain for
We're,
cause, it takes fewer votes to pass the resolution.
Correct.
Right, so it's, you're not voting against it if you abstain. for
Yeah,
cause.
you're not voting against or for.
You're removed from the denominator.
You are counted out. Yeah.
Thank you. We're getting to the highlight of the evening now.
Yay, Cocktails?
Link NYC.
the link.
You are on the stage.
All right, give me a moment. I need to, I'm just.
But you've had like 2.5 hours.
Come on, Justin, you're not ready. I actually read the whole thing like a good girl.
So I'll tell you what, while Justin is preparing, let me tell you that, first of all, the city council, I think many of you know, passed a series of laws on sidewalk sheds. One of them proposes that DOB consider rules that would extend the time period between local law 11 inspections and would increase the time before a new building has to have the initial inspection. Thank you for being with us.
Very interesting.
I know, right?
We could consider passing a resolution that supports, that encourages DOB to simply support, basically, to change the rules that make the inspection periods of local law 11, the intervals larger, and the delay from when a building is first constructed longer. So that's not something we're going to talk about tonight. I'm just telling you that's something that we could consider. That's different than the issue of protective fencing that's built in public parks. That is an issue that we will probably take up.
Yeah.
And it may be next month. Also next month, we will probably, so we have on tonight's agenda, a brief discussion of budget, issues. I'm gonna guess that we're not gonna talk about that very much tonight, because the sun is about to come up. But next month, I would like to invite DSNY and NYPD to share with us what budgetary priorities they would like us to consider. And in the course of that conversation, we can also get a better appreciation of what NYPD and DSNY care about, and we can ask questions. So I think that's a good way to get into the budget questions. And I'm just mentioning.
The other thing that budget asked us to do, because those of us who sit on the budget committee, we have our other committees. So what our homework was to look at what do other community boards
Yeah,
ask for
yeah,
in
I like that.
this, in this type of public safety committee, so that we can see, are we asking for things are there things that we could be asking
Yeah,
for
exactly.
that make sense for our district? So
And be
we can bring that, I
stronger.
mean, it's good that we're having NYPD here and DSNY, but
We're inviting.
I've also, well, yeah, if they don't show up, I'll at least come with my report
Okay.
on what other
Oh, that'd be great.
community boards have
Mhm.
asked
Yeah,
that are relevant to our
no, I think it's
context.
great.
That'll be good to know.
Okay, we're back to Justin.
Okay, so, want to do a quick presentation, run through this in like, a little bit more minutes. This is about an idea I had, Link NYC cleanliness campaign. This is about the Link NYC, what are those called? What's the word?
Kiosks.
Terminals, yeah. Which essentially have, a rotating advertisements that you see all the time. And one really, interesting thing about with community board is that we have access to be able to use those boards. Typically, that has been done with, let's say, there's a thing, a meeting is coming up. But about maybe 4 or 5 months ago, Mark Levine had a whole campaign about getting involved in the community that was a little bit more direct advertising. I am one of my friends who are someone who I know works for Mark's campaign, and I discussed with her about, or not campaign, works for Mark, and I asked a little bit about how that happened. How did this come across? And basically, she suggested that I reach out to the people who run Link NYC. They came back to me with essentially saying that we can use those boards if we do want to do some type of, I'll call it like advertising messaging. So
For free?
yeah, for free.
Okay.
So just kind of going through this. 1 second. So,
But normally it's not free for anybody, right?
not for, it's like $10,000
Yeah,
for
like that.
advertisement usually.
That's what my.
Wow.
So just kind of speaking a little bit about how I feel about the importance of cleanliness. I think that cleanliness is a really important part of any community. There's a lot of pride. I know this for myself when just something as simple as cleaning your own place. You feel good about the place around you. It's a cleaner community. Public perception is shaped by what people see on the ground. When people come into our community, Turtle Bay, and they see trash on the ground, they feel like it gives them a certain impression. I mean, truthfully, it's a really difficult issue for our community to, I think for any public, any city agency to address, because, we have so many people coming through this area every day. There's the litter buildup, sidewalk blockages. It's essentially an artery of Manhattan, and so there are objectively issues with the garbage that you see on the street. I wanted to bring up that one of the reasons I kind of was inspired by this was I visited Tokyo about maybe a year and a half ago. And it just will stun you what that city is like. The level of cleanliness is just incredible. When I came back, I kind of felt a sense of shame in the same way as like, imagine going to the most amazing, you go to an apartment and it's beautiful, and then you come back to your apartment and there's garbage. Like it just made me feel bad. I felt like I wanted to do more myself. But a lot of that is not just naturally cleaner, it's that they are intentionally cleaner. But part of it is taught in the sense of, or not just taught, but part of it is messaging. It's an important value to have. Just as any other cultural value that we have, it's important to be aware that that's, in my opinion, an important thing for to be clean, essentially. And part of, I do think we do a reasonably good job of education. that these are behaviors that are responsible. But it just, what Tokyo is doing right is really impressive. And also keep in mind, like, they don't even have trash bins. They banned trash bins in Tokyo because of terrorist attacks back in the 90s. So Tokyo is the cleanest city, and they don't even have trash bins. They literally are clean. They're carrying around their trash all day in like little bags, or they're just much more what's the word, like responsible or sustainable with what they take in, or what they use. But the point still comes back to that it is a lot of it is taught. It's not, they are intentionally trying to be clean. I wanted to look at some examples. There was a Harlem rat mitigation zone initiative about street cleanliness that was put in a few years ago, and there's some studies that basically said, and I could even add this to the resolution, but there's studies that basically said that the messaging actually was really effective with that. Here it is. The 15 to 30% drop in 311 rat complaints after combining cleaner infrastructure and community messaging. NYC's 311 system received over 82,000 sanitation-related complaints in 2023. So it's an issue, and messaging has shown to be somewhat effective. Obviously, and I think that's where I was talking about the cost line, is that some of these initiatives cost money, right? You go to Department of Sanitation, whereas Link NYC is a free resource that we have. Link NYC kiosks are installed across CB6, free, visible, pedestrian facing, capable of hyperlocal district specific messaging, used successfully with COVID-19 vaccines. It's a scalable, low cost way to build habits and just have people walk by and see some good civic values. Finally, and what people are more likely to support what they feel part of. The campaign that I'm proposing is going to reflect identity and diversity of CB6, images of recognizable local landmarks, professions and everyday activities common in our neighborhood, diversity of the community. I did include this about resident engagement and future outreach, but that's kind of like if this was something that people were enjoyed, that maybe we could reach out to schools or the community to find a way for them to be involved too. I think that'd be a different resolution in the future. But the point is, it's important part of this was having community involvement or people being engaged within the community. And so CB6 can lead by organizing, endorsing, guiding this effort. I also included potential collaboration with the DOITT and DSNY, but for future stages. And any messages or campaign designs that we use, it would, I don't know, we'd have to figure out how to have like an approval process, but the point is that it would be coming, it would be input from the whole group. So that's not just, Justin doing that and then I put something and then it ends up being like, mixed messaging with something.
Yeah, you want cohesive and.
Yeah. These are the guidelines for elected officials and creative specifications. Basically, because this is not about elected officials, I'm pretty sure you could use the entire screen. What I was told is that when we send it, it's like 5 days. We send them over an image and that's like 5 days later. So I brought some examples, I'm not sure if you got like some that are funny, some that but basically, these were ones that we could talk about how we want it designed, but trying to find ways to be kind of creative.
Yeah.
There's like the American, what's his name, Uncle Sam one, clean streets with the Chrysler building in the back. Basically generative art has infinite possibilities. Some of it's still hard to get, so like the one on the right, which I don't love the text is bad, but it is hard to like create like a real image still, but kind of cartoons and stuff like that. And that's some type of stuff that we can include. And then this last one, there's kind of like a funny one that I added to. So there's a little bit of humor.
That's
to that.
funny.
Yeah, I think, in that direction, if you come up with like, a character like they came up with the rats or whatever.
Yeah, okay, that's
Come up
exactly.
with a character, I
It could be a
think
character,
it's,
yeah.
people really like that stuff and they take to it and they, you could really get some really good
Yeah.
you know, images up there.
And this is really just an easy way to use something that we already have to do some fun messaging. And you know, that's kind of what my thought was.
And, okay, yeah.
Please.
Oh. Okay. So I don't know if you know that I started the Keep Murrayville Clean campaign,
Yeah.
right? So with that, it became like, you know, trying to get people to adopt their block, basically, and clean it up. And, you know, I've done a number of birthday events and just rally people on the weekends to grab, you know, take some grabbers and they're responsive. People will get into it, and I truly believe that they want to obviously be in better surroundings.
Mhm.
The messaging that I also feel that is important is for the businesses, especially out there. It's just, you know, there's parts that they just don't care. So maybe, you know, I'm just saying this just in light of what you're bringing forth here, and I think it's really, really great and wonderful. It's like, you know.
I mean, do you guys like I like the broader idea in general?
We definitely, yeah.
My
Yeah.
feeling is, you could have left the Link NYC part out of this.
Yeah.
And.
Yeah.
In the campaign in general?
And yes, and the concerns that you've raised, I think are all correct. I am concerned, and you did address this sort of, that public education and creative civic messaging has historically proven effective. I don't know if that's true. And I think that sometimes a campaign takes a degree of sophistication.
Mhm.
On the other hand, it doesn't hurt to try. And if it were integrated into a broader program, and so I'm not clear if, would we partner with, say, DSNY, or can we implement this on our own?
I think we can just implement this on our own.
Yeah.
That being said, we could partner with DSNY, or we could, you know, get more community engagement. But I think that is, you know, that's the next step. This is, you know, when I was going through this, those are all the same thoughts I had too. But I mean, this is pretty limited in scope in that way.
On Stu's point about sort of like you have a campaign, but the thing is like campaigns are effective if they're complementing something else.
Yeah.
So like, for example, the city is launching a composting initiative and they're totally changing that. Okay, so they're doing something that's changing the way we deal with our organic waste.
Yeah.
Then you've got a messaging campaign to tell people what they need to do differently, and that kind of goes together. So it feels like
I like that.
you need both components for it actually to make a difference
make a big
in
impact.
what you kind of see. So like we have half of it, and now where's the other
Yeah.
piece of it that's gonna like really.
And even funny stuff like that, like, you know, like, 'cause people are like, for one, they don't know what composting means.
Yeah.
Some people, they don't get it. They don't know what goes in the garbage can and what doesn't go in this garbage can and that garbage
Yeah,
can.
that's true.
But like even this one, so I sent Anne this one because we've been talking, like, you know, I sent her this image, and she brought up like her concern. She said, "Oh, it's really funny, but does that contradict, you know, the city's composting rules, or not rules, but new what's basically with the bins?"
Yeah.
Yeah.
it's a rule.
Yeah, it's a rule. So that's why I think it's good to have that sense, you know, figure out like what messaging we want to do. So, you know, we talk about it as a community board, so that, or whatever we decided, so that we know that the messaging is coming across the way we want to.
Is this a resolution, or is this a
Yeah.
program that we want to run out of the board office?
I wrote the resolution, but I wasn't sure that, I mean, I wrote it so that I had it on paper, but I don't know if it has to be a resolution. It's up to you. It's, you know,
I
to you
mean,
guys.
Brendan is sitting there with a stone face,
Yeah.
but
And you should doubt.
Yeah. Yeah, like, because we haven't done anything like this before, I'm not sure if this is the sort of thing that would necessitate a resolution or
Yeah.
not.
But even like something like putting the seal on, like that's something we need to, you know, it's an internal approval, right? Like when every time, you know, you're representing the community board.
Like, if we have support by CD6,
Yeah.
then would go
That's
back
good
to.
enough, I guess.
Yeah,
I guess, do we need to check it?
Yeah, like, that I would need that I would need to really look
Pressure.
into and ask Jesus and Sandy,
Mhm.
just because,
Or maybe you need to create a storyboard and, you might want to reach out to, obviously the board, even at the full board meeting and just say, hey, anybody in marketing here? Because we want to come up with a campaign or
Yeah.
whatever, I don't know.
I'm not a marketing, so, you know,
Huh?
this is all,
But
Yeah.
you'd need like, to say, like you're talking about some consistency and cohesiveness with what's going on right now
Mhm.
and
it's
how
something that
like
everybody
a
can.
real, like, it looks like a real campaign, like.
And there could also be partnerships with either the
Mhm.
bids or with DSNY if it's got any kind of a
Yeah.
program like this, and I'm not sure it does, except for a few posters. But I think that's very interesting, and it could certainly be something we kick off with the board.
Yeah. We could do a program, I mean, it doesn't have to be
You
resolution.
could position it as we'll be the testing community.
Yeah.
And, hopefully it'll get adopted by other communities.
So this may be a question for Jesus and for Sandy.
Yeah, I mean, on one hand, there's that portion of the bylaws that's like, the board only speaks through the words of its resolutions, but on the other hand, like, is a resolution needed to say, oh, like, the community board supports
Right.
our streets to be clean?
Yeah.
You know?
Maybe the resolution would be needed if we were requesting support from like DSNY. I could see that, but for the campaign itself, I'm not sure if it needs.
But do we not need just a general kind of agreement from the full board, since it will say Manhattan Community Board 6, that this idea should move forward?
Because it's public facing especially, I think
Yeah.
it needs to be.
I
Yeah.
think
I mean,
so.
think about it. We even passed a resolution on what our holidays are for the board, and that's internal business.
I mean, we
So-
can't speak for everybody. We really need to see what everyone thinks. And I think to do it through a resolution, just saying that this is the idea and this is what we want to do, and do you support it? It's not a bad thing, in
Well,
my
just-
opinion.
But just as a note that since this isn't time sensitive per se, that even if, like I discussed with Jesus and Sandy, and this does necessitate a resolution, it would be until next month.
We were
So-
gonna, we
Okay.
probably.
All right.
Either way,
Yeah.
like it's not something that has to have a final decision
That's
tonight.
good. So let's find out.
But,
Yeah.
Yeah, I can ask you.
In between now and then, maybe you might want to kind of do a little bit of a timeline, just so they say, like, just kind of see that it's thought out.
What do you mean by, you mean a
Well,
storyboard, you're
When
saying?
would you, storyboard, not only storyboard.
When
not-
would we start
when you
doing it?
talk- The timeline, like, when do you want to start it and when do you,
Okay, yeah.
over what period of time do
That's
you
a
want
good
to do it,
question, yeah.
especially with the league, how long would they let us, I mean, obviously if it's, well, I guess if it's free and it's a campaign and,
They told me they just said they said, send it over and we'll have it on the board in 5 days.
Yeah, and I'm sure for their planning too, it'd be nice to, obviously, it'd be nice to see that timeline.
Okay.
And if you present it at the board, it would be nice to see the timeline.
Yeah, and along with timeline, the other thing is for a campaign to know how effective it was.
Yeah, exactly.
How are you measuring the impact?
Yeah. And
So
how,
what are the indicators before the
Exactly.
campaign, after the campaign?
I was thinking about that.
So we know,
earlier.
was there any? Yeah.
Exactly, and.
There also is no, I will say, there's no like link or anything, there's no, typically in a campaign, you'd have like link to the DSNY and like a really effective campaign would have that. In terms of like, if I'm walking by on Third Avenue and I see this, like the most effective thing would be like, I could look at it and I could click on a link and it would tell me, you can
Well,
get
yeah,
involved in this and
That's
this.
what you might wanna think about, like.
But this would be a
have-
first step.
Okay.
That wouldn't preclude any of that. This would just be the very first step doing that to get it
Or
off the
just like
ground.
kind of, yeah, do it in phases where it's awareness first and then you do something where people can actually slap a QR code and join
Mhm.
on a weekend cleanup.
Yeah.
That kind of thing.
Yeah, and I guarantee Mark Levine's board would be,
Even I
or
feel like.
group would be supportive of that, because
Mm.
one of the ways I got involved was I went to an event where they partnered with Home Depot and we did like
Yeah.
a city cleanup, and like people just would stop us on the street and be like, thank you so much for doing
Yeah.
this, like,
That's
so
nice.
I think there are ways to build from this. It's a first start.
Okay, so we'll continue this with a discussion with Sandy, and we'll move to the very end.
promise?
You're still here, and you're still talking, and you're still upright. The minutes from the March 6th meeting were distributed this morning. If you didn't have a chance to look at them, then you don't have to approve them now. Also, I showed them to Anne, who wanted me to express more that the members of the committee had asked questions. I purposely didn't go do a narrative of the meeting. I just wanted to summarize what it was all about. So how do you feel about that? And would you be willing to approve it, or do you want to defer approval to the next meeting?
I motion to approve the minutes.
I second that.
Yeah, I'm fine with it. I do have a question about the minutes though. And so, I'm sorry if I missed it, but we're not doing like the AI recap on the minutes of the meeting with
I'm sorry.
the dictation. We don't do that here. We don't do the dictation recording.
We have the automatic transcription. Is that what you're?
Yeah, that's really
I
kind of-
distributed that.
Yeah, I saw it. I read it.
But so by law, if we have a video, we don't actually have to record minutes at all. The video acts as a record of the meeting. So my feelings are, and this is it's sort of my fault that this was actually what the bylaws committee did as well, is that the value of the minutes is to tell people, especially when we have a resolution, is for other members of the board to go look at the minutes instead of having to run through the entire video. And so the better that the minutes summarize what's transpired, the better it is at the full board. Oh, glorious about that.
But they're pretty good.
Ignore me.
I just thought about like someone taking down the minutes and keeping track, and it's like, is it better, or do we have, if someone's physically doing it themselves, is it better than the transcription?
I think
Or is
the
it not as
transcription,
detailed?
yes, because I think the transcription is very long and it's not that easy to read.
Yeah,
And it's much longer than, I mean, I think
Okay.
I think I did 2 or 2.5 pages.
3 pages, yeah, it was pretty
Yeah,
short.
and you know, I mean, it takes some effort
yeah,
to actually do that, but I thought it was worthwhile.
yeah, it's a nice exercise.
So any old or new business?
Wow, the bus stop on 34th Street, it's really. Later.
So would anyone like to,
Motion to adjourn?
that's it,
Motion to adjourn.
without objection. Thank you
Thank
all.